We're trying to slow it all down. That's our purpose, to de-escalate and slow it down. For those that may not know, we have to de-escalate not only the person, the consumer, but a lot of times the family is there and we have to de-escalate them as well. So there's multiple things going on scene, and ultimately we're just trying to help out everybody. We know that this is going to be a long-term problem. It's not something you can just put a Band-Aid on and it's going to go away. So we also have to make sure that the family knows and understands the process that their loved one's about to go through, and then also knows and understands what resources they have available to them as well. But what this does is it reduces the officer injuries, it reduces the time off of work, it reduces the workman's comps, and so that is for the betterment of everybody. It also ultimately reduces any injury to the consumer themselves. So these are some of the community collaborations and trainings that we have. NAMI is really good. Hope for Three, they are great. Local Mental Health Authority, Texana. So we have some projects that we're working on with them. We also work with the local hospitals and also the mental health hospitals here in Fort Bend County and also in Houston. So we have meetings once a month, and we invite them to come over, tell us about their services. They give us contact information because we're trying to coordinate all these services in the next step for these consumers on the side of the road or maybe at their house. And so a lot of phone calls take place during that time to make sure that we try to find the best place for them for what their needs are. Lions Club, Exchange Club are some other organizations that we work with. We also work with, like I said, Texana. They have a stabilization unit that we have an opportunity to take an individual there. Substance abuse programs, housing is a big one, and then post-incarceration assistance, so working with that discharge planner. Here are some of the goals for our program. We kind of talked about them in the other slides before, but reduce incarcerations with a jail diversion. So enhancing law enforcement response, again, safety for the consumer, for the public, and for the officer involved. Improve patient care, family support, reduce number of state facility admissions, emergency room admissions. We know obviously we're in the middle of a pandemic, so that really became something that we were having to work through with being able to serve our mental health community. If they didn't need to go to a mental health or to a ER, we were able to get them to a mental health hospital. But they also had constraints because everybody was having to practice a social distancing. So we were having to work through all of that as well. And again, decrease the impact with EMS services. So I want to go ahead and give the opportunity for Sergeant Ellis to talk with you all about everything that's been going on. I think I can see how I can get back out of the sharing phase here. Let's see.
Just press stop sharing.
Okay, I'm looking for that part.
While she stops shares.
Okay, go ahead, Ellis.
That's a good picture to share, so you're okay.
Yeah. So Lieutenant is exactly right. Just to kind of update those that haven't seen or don't know me, my name is Sergeant Ellis, Jerome Ellis, and I work with this amazing nationally recognized team, Fort Bend County Sheriff's Office, CIT. To kind of piggyback on what Lieutenant said, exactly that. We bridge the gap as men and women in law enforcement. I never knew that I would go into law enforcement and criminal justice to learn how to build bridges, but that's pretty much what we do. We bridge the gap between that individual that may be in crisis, resources that are available, staying within the networks of many of the individuals that are on this WebEx. So we try to stay in the current. We learned that the great machine of mental health moves a little differently than the great machine of law enforcement and criminal justice. So what we do is we act as liaisons to try and bring those things into agreement. As many of you know, at any given time, a director at one hospital can become a senior director or something else in 3 months from now, so those are the kind of things that the supervision stays up with. We stay, with our finger to the pulse of what's going on in the hospital community as far as behavioral health hospitals. We also want to make sure that we connect with those local groups that support the families. Lieutenant mentioned NAMI, and they have been such a help for us. They have even found occasions to nominate and award some of our team members for their commitment and their commended acts out there as first responders. This journey is a little different for me. I've been in law enforcement 22 years. Wow. And I'm still young. Wow. So I've been doing this for 22 years and found a passion for diversity and learning the community. And I'm proud to say that our team is a very diverse team, and it actually reflects the community that we serve. Not only that, this is I'm more of a stakeholder. I've been on a journey with my mom for my entire existence, understand the complexities of something like bipolar disorder and anxiety disorders and things of that nature. And I didn't know her diagnosis until I was in college. So this is very near and dear to us. We are completely in as far as accepting and moving forward with the duties and the things that we've been given, offered by our sheriff and our leadership. Just another thing I would kind of jump on and say is that we are currently moving in a swift direction, even in this pandemic, to create new tools, to form new partnerships within the ones that we already have, pilot new programs, opportunities, just to bring a more excellent service to the community members here in Fort Bend County. So we're kind of touching on, bringing on board, local mental health authority as partners in the cars, and will respond to scenes as first responders with us in a safe way. We're touching on these different angles of bringing education and training to those so that they can recognize CIT in juveniles and in children, adolescents. And we still partner with our law enforcement academy in the training of crisis intervention techniques and tactics to all local law enforcement here in Fort Bend County. So we got a lot on our plate, but we enjoy what we do, and we're committed to seeing it done. So those are just kind of a few things I'd like to piggyback with Lieutenant, and definitely wanted to reserve some time. I don't know, kind of if we could reserve time for questions, or if somebody had some things that they wanted to know more about CIT.
I just wanted to say, to kind of, again, piggyback again what Sergeant Ellis was saying as far as expansion, we are looking to expand the team. So we are trying to double the team, actually, with adding 10 additional CIT deputies. So we're working on that. We're working on a pilot program where Texana screeners will actually ride with us. And then we're also with behavioral health, I talked about the data, but they do so much more. So they help us really collaborate those services for those that are in need. There's a youth project that we're working on with them, some grant opportunities. So it's been a great partnership and a huge blessing for the Sheriff's Office to be able to collaborate with them.
Yeah. Yes.
Thank you. I think I mentioned it briefly, but we have an additional grant from the Department of Justice that was actually just released on February 11th, and I'm so excited about that because it's actually focuses on juveniles. So it's from the Office of Juvenile Justice Delinquency Prevention. That is a 3-year grant where our emphasis is on training law enforcement across the county, and again, using the work that's been done with the CIT and building that, on youth mental health, and also training court personnel on youth mental health and on trauma-focused services for youth. And it also includes developing an app and training providers, but that's an exciting project. So really fascinating, and it really complements, I believe, and really aligned with some of the new initiative that's been launched from the district attorney's office. So this is really great in terms of, starting to work with our young people and building that resiliency in our young people. And we know that training law enforcement, and, you know, to help identify and to help connect people to services is really, really critical. So, it's great. And the expansion of the team and the enhancement of the team. We're also looking at how we can use technology a little bit better in terms of telehealth and I think Lieutenant Budnick, also there's been some discussion about how we can enhance the mental health piece at our dispatcher level. So again, you know, if we can, you know, they're called intercept points. The more we can do at the various intercept points, the better outcomes we have, you know. And so we try to intervene early on, like that 0 and 1, which is public health, crisis law enforcement, because, you know, by 2, it's when they're booked. So after they're booked, it's a different process. So, you know, many of you have heard me talk about that. There's a whole like sequential intercept model. And then, of course, there's the reentry piece, which is often, you know, like level 4 and 5, that we know that we can have the better outcomes, both clinically and even fiscally more efficient if we intervene early on. So thank you. There is an opportunity for questions. We have a couple minutes, so folks can either unmute themselves.
Sure.
And I'm sure not everybody's going to unmute themselves at the same time and ask a question. I mean, you have that capacity, that capability. So if you have a question around CIT, please feel free to ask, or you can put it in the chat box.
Oh, let's see if I can read this chat.
Maybe it's just a comment about your hat, Sergeant Ellis.
You know what? There's a real history to that, and but it's a staple. It stays with me. Yes, indeed.
So there's no questions. So do you want to talk a little bit, Lieutenant Budnick and Sergeant Ellis, about how do people get a hold of CIT? Like, you know, I mean, that's
been an evolution as well.
It has been an evolution. You know, maybe the non-crisis number, but how does that work? Because obviously you don't have the capacity to respond to all calls. So,
right.
You know, I have a family member that's in crisis. I want you all to come out. And I actually live in the unincorporated. So how do I get a hold of you?
The best thing to do would be to give a call to the non-emergency dispatch number. They have been trained. They have the information that they need there to gain and gather the appropriate information so that we get the right response. Because there are a couple of elements that you want to consider. There's the mental health response, but then there's that element of substantial risk of danger. There's that element of danger so that they can get the closest person or the closest officer to that location. So our non-emergency dispatch number is 281-341-4665. There's a recording that comes on, and if you select the first option 1, press 1, it puts you through to our non-emergency dispatch. And our communications division, they're well trained. They also come and attend the mandated CIT training, the Sandra Bland class. A lot of you know about State Bill 1849. So they come and get that type of training so that they can, you know, pick up on what's going on, get the right questions, and it's recorded. I giggled a little bit at the beginning of your question because we used to have a phone number that went directly to our office and we forwarded it to our cell phones. So at 3 o'clock in the morning, my cell phone would ring with an excitement on the other end because a family was in need. And, you know, as grateful as I am for, you know, that honor, it became difficult to gather the appropriate information, waking out of sleep, things of that nature. So that's what we came to a crossroads and decided that the non-emergency dispatch number for unincorporated is really the best thing to do because they're trained, they're ready and they have the ability to gather appropriate information so that we can get the right response to that family in need. We are still working out some kinks. There's another phone number where people can leave messages. We go through the messages and respond to them accordingly. But many times the families have already gone through enough. They're desperate and they don't know exactly, who to call, what to say. They don't want their loved one to get in trouble. We hear that a lot. So they kind of look for the path of least resistance, and we don't want them to, leave messages on voicemails if there's an urgency. If there's an urgency, if there's a direct need, and a lot of times, that could hurt with the safety issues. So our encouragement is just to get them into our local dispatch. Mm-hmm.
And I do want to add, for those that live in the city, all the municipalities do have the opportunity to fill out a referral form.
Yes.
And so that is another part that our team handles. So our team not only goes to the crisis calls, we also follow up on any non-criminal reports for our agency that are involving somebody who the officer or detective feel they're suffering from some kind of mental illness. And then the cities have a form that they will fill out for referral for the citizens in their community as well. And so we get those, they get assigned out to our team members, and then our team members will follow up on those as well. Those are for people that there is no immediate crisis, but they do know that they need some help and some services.
Yes. Yes.
There's another question in the chat box. Is CIT available 24/7?
Not at this moment. 7 a.m. to midnight right now. The unique kind of partnership and brother sisterhood that we have with our night shift. There was once supervisor over CIT that now works directly with those night shift deputies. So we have kind of a brotherhood, sisterhood there with persons that are trained and have some expertise, on the ground if there's a need, if there's a CIT need after midnight. But I'll be very honest with you. When Lieutenant said that we slow things down, we don't slow things down in minutes. We really slow things down. Many of our officers don't come in until 2 or 3 o'clock in the morning after they've de-escalated the scene for a number of hours, worked hand in hand with the local mental health authority to try to figure out an inpatient response for whatever need is there, making that travel. They travel, so we go to the scenes in incorporated and unincorporated Fort Bend, but the resources may be in Humble or Baytown or Austin, and our deputies will make that trip. They'll make that trip to get that person into their services so that they won't, number one, we're going to try to divert them from jail, keep the ERs open as we can. But we want to find a good fit for that individual. What if there's a co-occurring substance abuse issue? What if this individual is considered to be, Jerry psych or somewhat up in age? So we just try to find the right fit wherever that fit is. So that's why we're a little bit more unique than, let's say, the traditional Memphis model. I know a lot of people have heard about the Memphis CIT model. We're a little bit different. We have the same drive and initiative, but we're designed a little bit differently so that we can tailor make those responses for the individuals. So I say that we run from 7 a.m. to midnight, but many times our deputies don't get in until very early in the morning.
And then somebody in the chat had a question as far as how do we help individuals who have already been arrested and charged on a mental health call. I know the magistrates are going to come up next to talk a little bit more about that process. But what we do is we coordinate and help plan with our discharge planner here at the sheriff's office. So if they know that somebody's going to be released, but there's some other things going on still, or they're going to need some help, maybe even need a ride somewhere, maybe to Texana, maybe to another facility, they will call us. We'll coordinate all of our efforts and make sure that they get where they need to go. So like I said before, it's not an open door just to let them out to the street.
No.
Yeah, I just wanted to add to that. I think we're going to be talking a little bit about that because that's where all the other partners come into play. The public defender's office, not only with the specialized legal representation, but also the case management, behavioral health services, you know, Susan Savelli, and what she does and some of the other supports. Again, the jail in terms of identifying and the discharge planning, and then also, you know, Faye's new role as a jail diversion coordinator to help, you know, again, fill in these gaps. That, you know, one of the great things about CIT is the flexibility. And I really have to say, like when the program was developed, you know, we built that in. So, and we had some of that flexibility because of the funding. But for example, as Sergeant Ellis said, a lot of the teams don't do follow-ups, you know, because it's like, well, why should law enforcement go out there and do follow-ups? Well, you know, law enforcement actually can transport somebody. They can actually go into somebody's house, whereas us as providers, often we can't. So that ability to follow up on a case is really, really critical. It's
Yeah, we want to make sure that we don't just stop at rapport. You know, in rapport building, I guess the ultimate goal is relationship, and we accept the fact that we will see our community members, especially those that experience severe mental illness. We will see them on a regular basis. We're going to see them, and we want to develop a relationship with them. So if I have to wake somebody up that has rapport with somebody, call them in and get them to a scene because I know that's the best outcome, you know, probable outcome, then that's what we'll have to do. So we want to extend past rapport into relationship, so that these families can finally get a breath of fresh air when their loved one may venture into crises.
great. Thank you so much. What we will do is, you know, we'll post this presentation and some of the information on our website. But Allison has done a great job in terms of communicating with you all and has everybody's emails. And which we have about 118 participants on right now. And I really have to say that with such a large group, I mean, everybody is being really considerate about, you know, logging on and off. If you just have to leave for 5 or 10 minutes, don't log off. Just mute yourself and turn off your video, because when you log off, then we get the beeps. So, you know, just so you know that. But again, it's been great. I know there's some way that we can minimize that, but we don't know how to do that yet. So, with that, so we will send out some of this information to folks via email because sometimes that's just easier. Like we can scan the CIT brochure, we can scan some of the other information and just send it out, Allison, via email to the participants. Thank you, Lieutenant Budnick. Thank you, Sergeant Ellis, for all that you do and for, again, just being the great partners that you are. So,
Thank you.
thank you. And with that, we are on time. I cannot believe it. This is so efficient. So I'd like to turn it over to, this is, you know, what happens after the individual is arrested and they're booked. This is perfect segue into our next presentation, because we have Judge White, who handles a lot of our magistrate docket, and Judge Tony Wallace, who is the judge of the County Court at Law 4. Do I have Judge Wallace? Judge Wallace, are you on? Oh, hi. I saw Judge White over there. There's so many people, but so I'm just really excited to have you join us. It's sort of, you know, that's the question. So what happens after they're booked? You know, often you're seeing these individuals sometimes within 12 hours of booking and sometimes 24 hours of booking. But so we'd love for you to just talk about that process and the information that's presented to you. And so again, I think I didn't know anything about Magistrate until a couple of years ago, but it's such an important, that front end is so critical. And sometimes we don't put enough resources on that front end. So I really would love for you to talk about the process and what your role is, and then folks can also ask questions. So Judge Wallace, do you want to start?
Absolutely. Good morning, everyone. Thank you so much for the invitation. And Judge White is going to, we're going to tag team on this one. I have actually some slides to share. Can I, if I click on the share, is it going to let me do it? It looks like I will. Okay. All right. So I think it's a perfect segue to go from the law enforcement role and the CIT team's involvement in assisting and facilitating law enforcement as it relates to mental health defendants or arrestees, whatever the terminology is that you like to use. But I think it's also important to focus on what happens once they are arrested. If it gets to that point that they are entered into the system, what happens next? And so one of the first kind of things that they have to go through is the magistrate process. And so I'm going to start with, hopefully you guys can see.
Judge, we're having some difficulty. We're trying to make sure you can share. So we're trying to make you there you go. Got it.
So I can't see anything right now. Hold on. Okay, there we go. My computer just takes a little while to like bring everything up. All right, so you can see this magistration process screen. Can everybody see that? Okay, I see Lori nodding, so I'm going to go with a yes. All right, so
we can see you. We can see it, Judge.
Okay, perfect. Thank you. All right, so I'm going to talk about the law and how the law dictates what the magistrate judges are going to do. And then you guys have the benefit of having not only Judge White, who has been doing our magistrate, but also Judge Brom and Judge Glover, I believe, are also on the call. And so they are going to share from a more realistic perspective, like the day-to-day, what happens in the actual magistrate hearings. So at the outset, we are dealing with the Texas Code of Criminal Procedure, and there are about 3 different areas or particular articles of that code that touch on how the mental health defendants are treated during the magistrate process. So in general, anyone that's arrested falls under the code 15.17, which says that all detainees shall, it is not optional, shall be given a hearing before a magistrate within 48 hours of arrest. So as you can imagine, in these COVID times, in these snowpocalypse times, I mean, any Hurricane Harvey, anything that's going on in the world that's impacting you at home or in your offices, it's impacting the magistrates as well, because we are under this mandate under the code to have a hearing for the detainees within 48 hours of an arrest. And the code doesn't care that we don't have power, and the code doesn't care that there's a pandemic or a virus going around. The code says what it says, and so we are required to give these hearings. So we have had to adapt in the COVID times, in the Harvey times, in the snowpocalypse times to accommodate and make sure that we are following the code. And so we are making sure that we have created Zooms and WebEx, and all these different procedures have had to be adapted to make sure that we are within and compliance with the Code of Criminal Procedure and giving these hearings within 48 hours of arrest. So I say all that to say, please be patient and accommodating with the judges as we are adapting. It's new to us as well. Sometimes the technology is new to a magistrate judge as well. So please practice patience as we are trying to follow the rules and make sure that we're doing what the law requires of us. All right, so the magistrate's role, so those of you who do not know what a magistrate does, all judges are magistrates, but not, so all magistrates have to follow what's under the Code of Criminal Procedure, again, 15.17. The magistrate's role is multiple, but I kind of highlighted the main things that the magistrate is required to do. First thing is to inform the accused of the charges. Sometimes there's one charge, sometimes there's multiple. Advise the accused or the defendant or the detainee of his rights. And there are several. And we make sure that we advise them of all of their rights, not just the ones that are convenient or the ones that are easy to explain. The magistrate's role is to advise that defendant of all of his rights. The magistrate also determines probable cause. That's when we are trying to determine whether or not there is enough just on the outset to decide whether or not we are going to actually keep the detainee in detention. And the magistrate sets the bail amount and conditions if necessary. So we're going to touch a little bit on the role of the magistrate. When you bring in a detainee or an arrestee who has a mental health issue, then you're adding another layer to what the magistrate has to do. And certainly we as the magistrates want to be sensitive to any detainee that may have any type of mental health issue. I believe the terms that are used now to appropriately address that would be any person that has mental illness or a person with an intellectual disability. And so we want to be sure that we are sensitive to that as we are completing our role as magistrate. It's imperative that we acknowledge and know if we're dealing with a detainee that may have a mental illness or may have been identified as having an intellectual disability. So that takes us to the Code of Criminal Procedure 16.22. And I think the title or the subsection Article 16.2, the title of it is actually very important because it literally says it is early identification of a defendant suspected of having mental illness or intellectual disability. That says from the outset, early detection, and that's why it's so important, because if we wait until 3 steps down the road to discover or to determine that a person has a mental illness or an intellectual disability, we could be causing more harm than good in bringing them through the justice system. And so early identification is so important. And I know that Dr. Almeida and several of the stakeholders that are also on this call have worked tirelessly to make sure that that early identification is indeed early, and so that we can deal appropriately with a detainee or an arrestee if they are identified as having that mental illness or intellectual disability. So on the outset, the code says not later than 12 hours after reasonable cause is established to believe the accused has a mental illness or intellectual disability, the jailer shall. And when you're reading codes and laws, any lawyer will tell you the words matter. And so if something says shall or will, it's very important. That means you don't have a choice. That means it is not in anyone's discretion as to whether or not that will happen. If the law says shall, then you shall do it. And so it's a time issue, right? We've already talked about they have to have a hearing within 48 hours. Now you're talking about within 12 hours after it is discovered. So we're going to talk a little bit about how that discovery happens, how they come upon that information. But if it happens within 12 hours, we have to get that notice. The magistrate has to be provided that notice. So what does that notice look like? It looks like this little form. I'm big on visuals, and so I wanted to show you what the form looks like. This is the 1622 order that is presented to the magistrate after a detainee is interviewed. That interview either happens through the Indigent Defense Office or through the Public Defender's Office, or sometimes both. After they have interviewed the detainee to gather up the information that's pertinent to their role in the magistrate process, this order is filled out and it is presented to the magistrate. This is the big red flag, the first red flag for the magistrate to say, okay, I'm dealing with a detainee here, an arrestee here, who may have some type of mental illness or intellectual disability, that gives us the indication that we need to treat this detainee accordingly. I'm not going to say they get special treatment or any special consideration, except that we know from the outset that we are dealing with a detainee that may have some mental health issues. And so this order does a lot. It puts the magistrate on notice, but it also helps to facilitate the mental health person. That person is going to now get some special services or special attention based upon what this order is requiring. And this order requires an evaluation if they haven't already had one within a year. It also requires a written report. And so the judge who gets this case later on, when they see this order in the file, they will also know to look for that written report, because the report is required based on the language in the order. All right. Again, still sticking with the code 16.22. It's really long. I tried to pull out some of the things that I felt would be that I felt would be relevant for this particular presentation, but you are welcome to pull out your code of criminal procedure and read the entire article 16.22. But basically, I wanted to also highlight that if there is reasonable cause, the magistrate shall order the jailer to provide those mental health or intellectual disability services. And I know that within Fort Bend County Jail, we do have those services that are provided once that detainee is identified as having mental health or intellectual disability. So what's the reality? That's the law. That's what the law says. We call that the black letter law. We know what the law says, but what's the reality of how that law is played out? How do the magistrates on a daily basis, because our magistrates do, they have a magistrate hearing every single day of the week, Sunday to Sunday. So what's the reality of what happens during those hearings? And it is a challenge. Dr. Almeida has talked tirelessly, and her department has given numerous presentations about the challenge of determining when someone has a mental illness or intellectual disability. And luckily, Dr. Almeida has also worked tirelessly, and her staff, to create some tools that are helpful for the magistrates to make that determination. And so I'm going to let Judge White take over from here because Judge White, as I stated, Judge R.G. Brom, Judge Tamesia Glover, and Judge Don Bankston are the associate judges who are doing these magistrate hearings on a daily basis. And so I'm going to let Judge White talk about what they are doing and how they facilitate this with these orders. Judge White?
Thank you. I couldn't unmute myself. Good morning. As Judge Wallace stated, my name is Judge Lewis White. I'm the Associate Judge for the County Court at Law in Fort Bend County. I think many of us can remember pre-COVID and the way magistrate used to take place. A lot of the lawyers can understand what we used to do before COVID and before the pandemic. Magistrate would take about 30 minutes to 45 minutes total. Now we're looking at about, if we're lucky, 4 hours, 3 to 4 hours of doing magistrate. So before we start, I just want to thank my staff, and I'm sure the other judges would like to thank their staff, because it takes a lot more work for them to complete magistrate. And before, it was just pretty much on the magistrate judge. So since COVID and since the pandemic, we have started doing everything virtually. As I stated before, pre-COVID, you can determine someone's mental illness or mental disability, intellectual disability, pretty simple. It was pretty simple. You could see them, you could observe them, you had time to see them get interviewed by the public defender's office and also be interviewed by the indigent defense. Now, because of the pandemic, it is one officer who takes what we call like a little tablet around to each defendant. And so when public defender's office interviews the person, they interview them pretty much by themselves. And then also when indigent defense interviews the person, then later on that afternoon, they will come, or that morning, they will come to us. And then we get a chance to actually conduct magistrate. So you have to be more intentional when you're trying to observe what's actually going on. And you also have to rely heavily on public defender's office and heavily on the ladies of indigent defense and ask them their observations of what's taking place when you're not present. When we talk about the signs earlier, you know, some signs are pretty obvious. You'll see someone when they're walking around with the tablet, you'll see someone in padded. So that's a pretty clear sign that they may have a mental illness. Also, you can look at the police report, and a lot of times, you know, examples of that would be a domestic violence case. You may observe in the police report, they may say something like that my spouse or my wife, my husband is off his medication. So that's an obvious sign as well. But then you'll have signs from the jailer who may state that they're not cooperating with the interview process, or they're giving them a hard time. And that's all indications that we look for as far as if someone has a mental illness or intellectual disability. Once we determine if they may need mental health assessment, of course, as Judge Wallace stated, we fill out the 1622, and we can also make that a condition of their bond, so that they have to have that mental health evaluation in order for them to be bonded out. And we can, and as it states on the slide, that we can also order other conditions that are reasonable for the defendants to appear in court. Some of the things that we have to deal with on an everyday basis is that, as I stated before, is that the time that you actually spend with them is short. So you have to make the determination rather quickly. I think Dr. Almeida stated yesterday that 99% of the people that we refer are found to have some type of mental illness or intellectual disability. I'm sure that we're missing some people during this process. And it'd be interesting. I'm sure Dr. Almeida probably can talk about it later, or she has the numbers, the difference between the numbers now versus pre-COVID. Because I think that at that time it's probably a little. I would beg to differ that probably the numbers are probably a little bit higher pre-COVID. When we once you find out that someone has a mental illness or intellectual disability, we try to make sure that we can slow the process down for them, make sure that they understand each and every bond condition. Also, if it's an emergency protective order, we know they can be convoluted. And so we try to make sure that we explain every aspect of that protective order to make sure that they understand. And then we try to work with, when we assign, we appoint the mental health public defender's office, or even if we appoint an attorney that's not part of the mental health public defender's office, we try to ensure that we're looking out for the public safety, but also the rights of the mentally ill person as well, because we want to make sure that we're not holding someone in jail just because they're mentally ill. Now, I think we wanted to talk about Well, first of all, let me just ask if anybody have any questions. I know I kind of went through that pretty fast. It's kind of hard to see anybody. I mean, see people with the with the slide up, so I can't tell if anybody has any questions. As Judge Wallace stated, I think Judge Glover, I saw her on earlier, and Judge Brame, I think she's doing magistrate at this time. She was on earlier. Oh, she was on earlier, and Judge Bankston. I do magistrate on Wednesday, every Wednesday. Judge Glover Monday mornings, Brame Tuesday mornings, and Judge Bankston on Thursday morning. We alternate Fridays. And I think this is Judge Brame's Friday. So if anybody has any questions or you want to log in sometime, you're more than welcome to do that and see how we actually conduct it. Hopefully soon, we won't be doing it virtually. You have anything else, Judge Wallace?
No, you did a wonderful job. Thank you, Judge White.
Okay.
I don't know if Judge Glover wanted to add
Judge Glover,
anything.
yes, Judge Glover, do you have anything to say? Judge Glover, I think you're muted.
Yes, I am. I was waiting to be unmuted. Thank you. So this mental health specifically is a passion of mine. For those of you who don't know me, I am Judge Smith Glover. Prior to being appointed judge, I headed the mental health group, which I'm hoping becomes a full division so that attention, but for the county attorney's office. So my role was directly working with mental health individuals in a commitment process. And so I think that now as a magistrate too, it gives me a unique opportunity to identify some of those times where maybe it doesn't come out in an indigent defense interview. Whenever I do magistrate, I am looking at not just because like Judge White said, if you're in person, you can kind of see someone's demeanor and you can determine, okay, maybe there may be some mental health concerns. Maybe we could at least order an evaluation. But I'm also looking at the probable cause. I am looking at the crimes. When you look at the probable cause, you want to look and see, what exactly happened in the situation. If, it's a if it's like an assault case, and what did the person say during, what was the purpose of that assault? Did they feel that they were threatened? Did they feel like I said, I'm looking at when people were getting committed, the things that they would say and do, and then now looking at when they're getting arrested for some of these things. If I see any type of correlation, even if it isn't identified early on, I'll at least order a mental health evaluation and potentially appoint or request an appointment of a mental health public defender. Looking at the types of crimes, I know there's studies, on both sides that say that mental illnesses aren't tied to specific crimes, but when you look at something like our criminal trespass, that's something that comes up in mentally ill or in cases with individuals with mental illness. I mentioned some assaults. Of course, I'm drawing a blank right now of others. So, but we're also looking at those types of crimes. We're looking at if, what does the defendant say when they're in the middle of magistrate. A lot of the time, we, like Judge Wallace says, we advise them of their rights. One of the rights, we tell them you have the right to remain silent. You don't have to make a statement, but any statement that you do make will be can be used against you in court. And even with those rights, they want to tell you about everything that happened in that situation. And it's important that, and we do, when they do speak out, we obviously try not to get into too many of the facts of the case because it goes beyond what magistration is. But if they're saying something that's a trigger, that's what we pick up and we'll order a mental health evaluation. So you know, sometimes we'll get the 16.22 ahead of time just from the previous interviews, but other times we have to pick up during that magistration on some things that may not have been picked up before. That's all I have to add.
There is a question in the chat. Oh, Judge Brahm, did you have anything else to add to that? You're on mute.
Muted, Judge.
Thank you.
There you
Okay.
go.
Good morning, everyone. I'm Judge R.G. Brame. The only thing I want to add is because I had the opportunity to work with the Public Defender's Office doing magistrate court pre-COVID when we did meet in person with each of the defendants. And it really was much more ideal as far as having that short but closer relationship with the inmates and being able to better assess any sort of possible mental health issues. It definitely made it a lot more difficult after we went virtual on WebEx because you don't have them in front of you, and it requires a little bit more to be able to identify it. So I definitely felt that I definitely feel it's different to do it via WebEx as far as that relationship with the client. And now as a judge, I have even less time with them because I'm not actually interviewing them and asking them all the questions that I would want to ask. So we really do need to rely on the Public Defender's Office and any other information that we might have to be able to identify a mental health issue. So it really requires everybody to work together.
Thank you so much. There is a question, and when we are appointed to someone who's been identified as mentally ill, can we be notified of that? And I'm assuming can we be notified that an order has been issued or an assessment has been completed? I'm sure that's the question. And yes, so part of that order and part of that Senate Bill 1326 actually requires us, the system, and so Behavioral Health Services we're doing this piece right now. We actually take all those orders that come in. We also monitor the notifications of magistrate, but we take all those orders that Judge Wallace talked about, those 1622 orders. We review them. We reach out to the jail if the individual is still in custody to get the corresponding assessments, which have to be on a special form. And then we file those into the corresponding cause numbers. So, these individuals often have multiple charges, so we have to file it, with district or county clerk, and we file those and we email the attorney on record. If there is not an attorney on record, then we send it to the Public Defender's Office, because that's often who's assigned at that point in time, to the Mental Health Division of the Probation Department, the Mental Health Division of the DA's office. So if you are appointed to someone, you should be able to get that information. Sometimes we don't know of that appointment early on, so you might not get that email notification. And maybe, Mr. Glass can talk a little bit about that, about what happens. As Judge White said, and Judge Wallace, we actually had a presentation on this yesterday. So we have a variety of data that we've been tracking. We've been tracking this information since August of 2018. There's some variability, but on the average, about 8% of the individuals that are booked have an order for a further assessment. So as we've talked about that, what we're trying to do is at multiple points of this criminal justice system, develop processes so we can identify individuals. So we kind of talked about that early on with CIT. Identify them, divert them, connect them to services if you can, okay? So then if they're booked, and the jail will talk about this, they do a screening, right? Then it's the magistrate court level. Let's say we still don't identify. Well, the jail has other processes then. There's also the mental health court. And in any time during that involvement in the court system, you know, we often get an order saying, hey, we think this person might have a mental illness, you know, and often people develop a mental illness. They, you know, things might obviously destabilize. And so then later on, you know, let's say, you know, the case could have been 6 months old and you start seeing this deterioration in functioning, you know, the individual not understanding and increasing in depression, anxiety disorders. They get off their medication, so they decompensate. So there's different points of the process where we hope to catch and identify those individuals so we can connect them to the appropriate services. I have to say, we did not practice these presentations or this seminar, and I am just so impressed of how smooth it's going and how it's staying on time. So I think this is amazing. So I really, really appreciate everybody. Again, if you have questions throughout, you can put them in the chat box. We can always, you know, you can send them directly to the individual that presented. And again, we're trying to get as much information out there as we can. So I'm moving to the next. Thank you, judges. Really appreciate it. Thank you. That was great. So we're going to move now to the next panel, which is really the next step. So what happens, you know, what happens when the individual is booked? So we already talked about the magistrate process. We talked about the key role that the jail plays, both in the booking process, but also the mental health folks in terms of the identification and the screening. Of course, the public defender's office from early on, their involvement, and throughout the process, the probation department and the DA's office. So this is a perfect segue to go into that. And I believe, Major Zamora, I don't see you, but I also have to say we have 126 participants that have signed on, and it's great. So I'm going to turn it over to Major Zamora, and then Jarrell Cardiff with WellPath, who's our medical mental health provider in our jail, and she's the health services administrator. So Major, welcome.
So good afternoon. I thought I'd speak just briefly on the intake process when an arresting officer brings someone into the jail that may have a mental health issue. And the very first thing that's done is what I refer to as somewhat of a search for pedigree. In other words, there's a pre-booking medical clearance form where someone actually approaches an arrested person and asks them specific questions about their condition. But even before that, there's a requirement that the person be able to walk in themselves. If the person is not capable of walking in, then the arresting officer is referred through acknowledgement form to either an emergency room or a hospital, so that person can be cleared for incarceration. But then afterwards, there's the typical questionnaire that's about 4 or 5 pages. It looks very specifically at the condition and symptoms. This is the Suicide Medical Mental Developmental Disability Questionnaire. And so that looks at what the pre-existing conditions are and what kind of physical and mental condition the person is in that's being brought into the jail. So if there's a concern that the person is, say, too intoxicated, too belligerent, uncooperative, or if there's a significant problem that the person's not cooperating and not able to provide any kind of information, then that person, if it's a legitimate charge, they're put into a cell and they're watched every 2 hours until they can complete the pre-booking process. Once they're capable of responding to questions, then they're actually booked into the jail, and their information is put into the Tiburon, the records management system, and they're given a booking number. So it's at that point that certain data has already been input into the system, and that's what can later be used and exploited for research purposes. In other words, what kind of condition are people coming in? What types of medications are they requiring to sustain themselves? And if they have any medication in their possession, that's noted, photographed, and it's also safely secured. Later, there's a medical team that actually goes with a medical cart providing the prescription medications that they're using. And so because there are costs associated, there's a very minor copay. If an inmate has an account, there's a copay of $3 to $5 for any type of medical work that's done. So probably the largest expense that the sheriff's office has is related to medical costs for inmates. At the current time, there are about 811 persons incarcerated. Occasionally, there are people that are held temporarily for the U.S. Marshals or for other counties. For example, we're currently housing 30 inmates from Austin County because of flooding and some reconstruction work that they need in their jail cell. So we do have agreements with other organizations, other agencies to temporarily hold their prisoners. In terms of making outreach to other agencies and other organizations that can help the sheriff's office with inmate needs, WellPath does an excellent job. They're usually involved in small groups and with individual face-to-face assistance. However, because of COVID, that's been somewhat restricted, but also has the drug and alcohol abuse assistance that we've had for inmates. So while there were small groups that participated in drug and alcohol abuse counseling, that's been limited somewhat. But with time, I think that'll return. And meanwhile, we also rely upon jail ministers and jail ministries. And so we have an agreement with an organization for ministry work. And finally, the SB, I think it was, I want to say it's 1849 with the Sandra Bland changes. The sheriff's office has done very well. In fact, we've created a 16-hour course that will include de-escalation and then mental health, and just to continue educating the entire sheriff's office on mental health issues and the proper interventions, the proper handling, de-escalation, crisis intervention, etc. You heard earlier from Lieutenant Budnick, so we're blessed to have a unit like that may soon be a training site for other organizations, other police agencies that are interested in improving their mental health services. And the Senate bill also required certain things, reporting requirements. I know that the magistration process was something important that was discussed earlier. So if someone has a mental health issue and there's a possibility of magistration, they're watched every 6 hours. And as you know, those reports are timely made within 12 hours. And at that point, that's really all I have. I'd like to turn it over to the next person or answer any questions that you might have.
Thank you, Major,
Thank you.
and welcome to Fort Bend County.
Thank you. Yeah, I've been here 2 months and we're learning quite a bit.
Thank you. With that, I'd like to turn it over to Jarrell. Where are you, Jarrell? Jarrell and Donald, thank you. I think we have email communications every day asking Jarrell and Donald about questions. And so Jarell, as I mentioned, is the Health Services Administrator with WellPath, and Donald is the lead clinician with WellPath. That's at least how we know you. And so love to turn it over to you and talk a little bit about what you do and when folks are incarcerated in terms of mental health. Thank you.
Good morning, everyone. So first off, when an inmate comes into the jail, they see the nurse. And as Major Zamora mentioned, we do the Texas suicide screening form. Along with that, we review their chart to see if there's any previous mental health history in their chart from previous bookings. When they have an answer of a yes on any of those questions, or we find a history in their chart, then they get referred over to the mental health professional. At that point, I guess I'm gonna let you talk about what goes on after they see the mental health professional.
When there's a positive on the suicide screening form or a positive CCQ match, we come in and interview the inmate and try to identify what kind of mental health needs they have, look at the history, look at their current level of functioning, look at their need for medication, and try to identify any kind of risk factors that might be there that could lead to, problems in their functioning in the jail. So when we do that, then we make our referrals to we'll complete a preliminary or an initial assessment, and we'll send that information onto the detention court updates area, which will allow them to be identified by the courts as having a possible mental or either a mental illness or some sort of intellectual deficiency that that will lead to problems when they're incarcerated. We also, as Connie was saying, there are other times when we come in and look at the inmates functioning. We frequently get phone calls from family members that will identify problems or even problems that are identified by CIT when they've had encounters in the community with these individuals. So even if the inmate does not endorse those questions when they come in, we'll oftentimes see them at another point when we get referral information, or even sometimes referral information from the deputies here in the jail who interact with them and see that they're not, they're not functioning the way they're, the way that we would expect them to be able to function if they didn't have a mental illness. So there's other points at which we may come in and do an assessment and identify mental illness or intellectual deficiencies.
The nursing staff also, along with the suicide screening, when they're getting their medical information, will find out about medications that they may be on, find out what pharmacy they get them from, so we can call to verify that medication. Once we get the verification, we can go ahead and get an order from the provider to start that medication as soon as possible. We also have Andrea Fields that works here with us as a discharge planner. She does a lot of the behind the scenes work for medications as well from Texana. If we have someone that has a positive CCQ, our system is set up to automatically send an email to those people at Texana to say, hey, we have a positive CCQ match. So then they know we need their medication history, and they send that over to Andrea so we can get it started as soon as possible. We also have a meeting once a week that includes, let's see, the people here in the jail, mental health professionals, the security side, Texana representatives, public defender's office representatives.
LaShondra, people from probation as well as from the district attorney's office.
In that meeting, we can discuss everybody that's kind of on our radar. collaboratively to make sure we're doing what's best for those people. And I think that's about it for our department.
Thank you. Thank you. I wanted to share, I'm going to try to share briefly because we've talked a lot about this screening form. So I was actually able to pull it up. Let me see if I can just share it. Okay, so when, I think you can see it. This is the screening form that folks are referring to that's required by jail standards and needs to be completed for everybody coming into the jail. And usually completed, I mean, Jarrell, right within like 2 hours of booking.
Immediately.
So yes, so this is also what prompts that notification of magistrate that something's going on. So this is the screening form. Believe me, part of our BJA project, it's like we're more familiar with this screening form than we ever wanted to know. So just wanted to share that with folks. Just wanted to, Jarrell and Donald talked about CCQ. That is a continuity of care query that is, and somebody, if I misspeak, that is an automatic matching process between the Department of Public Safety and the Department of Health Services. So when somebody is booked into the jail, there's an automatic query that tells you if the individual has ever been served in a state-funded hospital or a community mental health center. It gives us very general information, doesn't give us diagnosis, but it gives us an indication if the individual has been served in those systems. So that's what the CCQ, and Ms. Body knows a lot about those CCQs, and we'll talk about that. But again, it's kind of like, okay, here's a high-risk individual. They've been served in the public system somewhere. So most likely have a serious mental illness because that's what qualifies you to be served in those systems. So thank you, Jarrell and Donald, for that in Major. So with that, perfect segue into the Public Defender's Office. And Rocky, once again, thank you so much for coordinating the CLEs and helping us with all the rescheduling. This seminar was really focused on getting our attorneys and legal folks, kind of to learn more about the processes. We try to get TCO credits, but apparently we have to be live in order to do that. So the next seminar will work on that. So thank you, Rocky, and I'm going to turn it over to you, and I'm going to share your screen if I can find it. Hold on. I'm getting there, Rocky. Can you?
Okay. I can probably share it myself if you give me just a second. Here we go. Okay.
You got it, Rocky?
Yeah. Okay. You see it at least?
Yep, we see it. We're good.
All right. That's the CLE information that's important for the attorneys. If you've actually given your bar number to the Allison Becerra, I will get that and I can enter it for you. That'll be later today. If not, this is the information that's there, so you can actually begin that so that you can actually have that available for you. Real quick, I'd like to thank everybody that's spoken already. The Public Defender's Office really starts at magistration. Judge Wallace mentioned 1517, and right now, for the last 2.5, almost 3 years, public defenders have been at magistration. And one of the things they do is determine if someone has a mental illness. And that information is presented by partially by the jail, partially by Connie's office, partially by observations of the attorneys. I think it's important, and Judge Wallace mentioned that magistration happens 7 days a week, 365 days a year. And even during the freeze, it can be very difficult for unexpected things to happen. We didn't expect everybody's power to go out all at the same time. And so it was very difficult during that period of time, just just to complete magistration. But it's important that people understand that people get arrested, 7 days a week, 365 days a year, and so magistration has to happen every single day, and it's important what the judges are doing, what the DA's office is doing, and what the public defender's office is doing there. Really talking about mental health court and working with, there's a collaboration that happens between the jail, the sheriff's office, the probation department, and the DA's office on every single mental health person that's there. And Connie's office mentioned the work that they do and the Senate bill that actually requires that information. And as I mentioned yesterday, part of that, what the legislature wanted to happen was so that no one gets lost in the system. That there's always catches so that someone is always caught that has a mental illness that's in that system. And without that without that information, it becomes very difficult for it to happen. And people get lost in the system in the past. And Connie and I have been here for about 11 or 12 years, and in the past, people have been lost in the system, and now there are all of these catches so that people don't get lost in the system. We've had people that have been lost in the system that have stayed in jail for almost 9 months before someone has caught this person has a mental illness. With all of these catches now, we're trying to prevent that thing from happening again. When the mental health court started, the collaboration between probation department, the DA's office, Connie's office, and the sheriff's office on every single person that's there, as well as the particular judges that do mental health, is there so that we can actually give the special care to mentally ill, so that we try to cut down on the recidivism rate. We try to cut down on the things that gets people back into the system. We have social workers and case managers that actually work with each individual so that they don't come back into the system. And sometimes that works, sometimes it doesn't work. And each time we try to think outside the box. And Connie's office has been very helpful in trying for us to think of things outside the box to happen so that these people don't actually come back into our system. And some, like I said, probation, does their job as well. And sometimes we have people that are very severely mentally ill, and unfortunately, they can't be on probation. They can't. They don't belong in prison, but they can't be on probation. So we try to think of some things outside the box, and we think of as Judge Glover mentioned, we actually try to think of things of going a civil commitment or going a different way of actually trying to help these individuals. And unfortunately, the ones that are incompetent, one of the problems that we face, and the jail faces also, is the wait list to the state hospital. Unfortunately, the wait list to the state hospital is a year now. So if someone's incompetent, it takes a year before they get to the state hospital. They spend that time in the Fort Bend County Jail. They're mentally ill. They're severely mentally ill, which means they don't understand anything that's happening. But they're spending all of that time in the Fort Bend County Jail. And that's a problem that I think Connie's office, my office, and several other departments are trying to consider what we can do for that. If they agree to take medication while they're waiting, then Connie's office has offered to actually, reevaluate them. But unfortunately, we have those that refuse medication, that refuse anything, and unfortunately, they are staying in jail very sick for more than a year before they get to the state hospital. And that's an issue that unfortunately we haven't come up with a solution for yet. And with that, I'll pass it to the next person.
Thank you, Rocky. I had to smile when you said outside the box. I remember Lieutenant Soland, who helped start the CIT team, and I was accused of being a tree hugger. You know, it's like, you know, I remember the first meeting and I'm sure he was dragged to that meeting by, you know, the jail administration. Probably go listen to Connie. She's talking about CIT and jail diversion again. And so it was interesting because he'll talk about, you know, he just thought I was a tree hugger trying to save everybody. So I think outside the box is good, Rocky, sometimes. So I'll talk a little bit about a project that we're looking at for children of incarcerated parents. So we'll be really outside the box on that one. So with that, I'd like to turn it over to the district attorney's office. And what's interesting, when we started this work, you know, 11, actually like 12 years ago, I mean, really, we started with funding for 6 hours of a psychiatrist per week in the jail because we had nothing. And the DA designated a mental health prosecutor, and probation designated a mental health person. And then Rocky's office came on board with funding from the Indigent Defense. And I don't even know how it started, Rocky, maybe with 3 folks or 4 folks, and has really expanded to, you know, a really robust team. So
Started with just over Zena and I.
okay, yeah, I couldn't remember. So Donna, welcome. I think you're on mute. No? Okay, let's Allison, can you unmute? Can you try it now? Okay, I'll try to unmute you. No? No. Let me see what's going on. Should be. You're not unmuted. Hold on. Hey, this is our first technical glitch. So, you know.
You can maybe try calling into the number that was sent with the WebEx link as well through your phone.
Yeah, but that will cause, can you try again, Donna? Still not? Okay, can we do something else? Can we go to probation and then come back to you? Is that okay? Miss Body, can you unmute yourself?
Can you hear me now?
Yes.
Okay.
Okay.
Good morning, everyone. I am LaShondra Body, the Mental Health Officer for Fort Bend County and Senior Community Supervision Officer for both misdemeanor and felony mental health courts. I have been a probation officer in Fort Bend County for 17 years and a mental health officer for approximately 13 years. I would like to give a brief overview of my role as mental health officer and the role of probation as it relates to defendants who are on probation on a mental impairment caseload. As the mental health officer, I am involved during the magistrate process. I receive the countless CCQ emails that Connie spoke about earlier, sent to the judges and Texana Center regarding those defendants who are arrested that have a mental health disorder. I work with Indigent Defense to ensure that these defendants have court representation. There are occasions that I recommend that the Public Defender's Office is appointed if the defendant has remained in custody and not appointed an attorney. I also take this information to make referrals to the ADA Mahmoody and ADA Morton for defendants who qualify for mental health court or have been in services with the probation office before. For misdemeanor mental health court, if the case is rejected for mental health court, the defense attorney is able to contact me for an appeal. I work directly with Judge Morales to review the case to determine if the defendant should be reconsidered for mental health court. Once the defendant is actually placed on probation, they are supervised on the mental impairment caseload. The benefits of the mental impairment caseload is that our caseloads are a lot smaller than a regular caseload. Usually, probation officers supervise anywhere from 115 to 125 cases. The mental impairment caseloads are kept between 45 and 60, with 60 cases being our caseload cap. We have currently 4 mental health officers, including myself. Defendants who are on a mental impairment caseload are also placed in mental health court. One difference of our specialized caseload is that we are in contact with the mental health providers. We speak with the psychiatrists and nurses to ensure defendants are reporting for their doctor's appointments and taking medications. We also have those defendants who have issues taking their medications to bring their prescription bottles to the office. We sometimes count pills, take them out, help the defendants determine what pills to take on what day. We're also in contact with the family members as collateral contacts. We try to involve those supportive family members to encourage defendants to remain compliant with their medications as well as probation. We try to build a rapport with the family so they feel comfortable coming to us with concerns about the defendant's mental health. We also conduct field visits. Sometimes our defendants are more relaxed in their own environment. We're able to see their home life and what environment they're living in. This is very helpful to our office. This sometimes explains the non-compliance of our probationers. If their home life is unstable, they're sleeping in the garage, sleeping on the couch, the house is unsanitary, etc., this will definitely affect their mental illness. So we try to utilize that information to attempt to help the defendant with their stability. We also have a very collaborative team with our mental health ADAs and our mental health division of the Public Defender's Office. We staff our cases before mental health court to determine what is in the best interest of the defendant. It is not the normal approach of most defense attorneys and probation, but the goal is to service the mental health defendant. Mental health court is used to reiterate to the defendant the importance of remaining compliant on probation and taking their medications. I'm also involved in the weekly jail staffings that the jail staff mentioned earlier. This is also a collaborative effort between probation, the district attorney's office, the public defender's office, behavioral health, Texana Center, and the jail. We staff the most mentally ill cases that are currently in the jail. I'm able to staff those defendants who are on probation on our mental impairment caseload to determine how they are doing in jail and if they are medication compliant. Although it may not be popular opinion, we all know that the jail is the largest mental health provider. It sometimes takes our defendants being arrested, going into custody, getting back on medication, and then becoming compliant. So the jail staffings are very important to all agencies involved in continuing to discuss those defendants and come up with a plan. The mission of the probation department is to protect society, but as a mental health officer, the mental health needs of the defendant are also considered. I thank you for your time, and if you have any questions, I will place my contact information in the chat.
Thank you, Ms. Body. It's a great overview of the system. Thank you so much.
Thank you.
Donna?
Can you hear me now?
Hey, we can hear you.
Great.
Accomplishment.
My name is Donna Mahmoody. I am the chief of the mental health division, which consists of myself and Leslie Morton at the district attorney's office. And I have to tell you that we are both very proud of the work that we're doing here, and it is our goal to keep evolving to meet the needs of all of our defendants who have mental illness of any kind, and also to streamline the process to make it easier for resources to be linked and provide those resources. Let's talk about first how we get involved. And the district attorney's office, as you all know, has prosecutors who are assigned to magistration. Sometimes we receive referrals of cases from them. We also receive referrals from law enforcement directly if they've been in contact with individuals who present with a mental illness and law enforcement believes that they need assistance in addition to the criminal investigation that they're conducting. We attend the jail staffings weekly with the public defender's office, with probation and behavioral health. and we will sometimes take cases from those instances so that we can step in early on in the prosecution of a case and hopefully formulate some bond conditions to help the stability of the individual and make sure that the safety of our community is protected. After that, there are cases that are referred to us, as some of you know, by completion of the mental health applications. We receive those and review them and make offers. And the offers vary from pretrial diversion on some all the way through deferred or straight probation. Our goal with each and every case is to help stabilize that particular individual and get them the resources they need through our partner agencies. We do also like to think outside the box, and we're very aware that a lot of our mental health defendants are also victims of crime and victims of other circumstances, and we partner with other agencies, including the Fort Bend County Women's Center, to try to provide them with resources that might not be available through our local mental health authority. The mental health court is different. If you're used to seeing prosecutors in the courtroom and you think that maybe we are about the law and order, and we are, our mental health program is such that we expect there to be hiccups. We expect there to be non-compliance, and we don't take a dramatic step to end someone's probation or community supervision at the first instance. Our goal is to help them through the process and make sure that they have access to all of the resources that are available while we work with the public defender's office, with probation, and behavioral health to see if we can provide anything else that might make this person successful. And successful is a very relative term. It starts with just stability in their possible medication compliance for their health as well as their mental health. And then we step forward to things like housing and employment, and go beyond that when we can. On a daily basis, we get emails from the jail about inmates who are in custody, who have mental illness, and we try to relay that information to the appropriate defense attorney, and we let the prosecutor who's assigned to that case know. We also try to provide assistance with any bond issues that we can. We also help with the competency evaluations, and what you'll see from us is that we'll contact the prosecutor to whom the case is assigned once we receive an order for an evaluation, just to let them know that the evaluation is being conducted. And we monitor those cases and review the competency evaluation reports upon receipt. We are now drafting all of the competency restoration orders to help facilitate getting people on the waiting list and off to the hospitals in treatment faster. We're also making great referrals to behavioral health. I know that we keep them busy, and we do that with the public defender's office too. Anytime there is a defense attorney who is not with the public defender's office, we encourage them to communicate with the public defender's office mental health division. You would be astounded by the level of service that they can provide to you, and the social workers that they have, the case managers that they have, and they are a great resource to defendants with mental illness who need that additional layer of support to help to keep them stable. They will provide transportation at times to appointments, to docket. They are able to locate housing, all of those things that perhaps a private attorney doesn't know exists. The behavioral health division has helped us in so many instances in that they are able to communicate with the defendant's family members to provide collateral information, which is necessary for us to get them the treatment that they need, especially when a defendant, him or herself, is not volunteering that information because their mental illness is so severe. I'll share my email address and Leslie's email address in the chat box for everyone. If you have any concerns with a particular mental health court application, please let us know. Contact us by email. If there's something that you believe that we can do better or differently, please let us know. We're happy to make at least an evaluation of that to determine what we need to do to better serve our citizens. And I'll turn it over, Dr. Almeida, to whoever else, or if there are any questions.
And also, I'm sure if folks can contact you if they want to know, like, again, more specifically, how to make the referrals to mental health court. I mean, either you or Ms. Body, but the forms that are needed, because we're really trying to get attorneys to initiate that process, right? Okay. I think you're on mute again. Oh, okay. Somebody unmute her, please.
Can you hear me?
Yeah, now we can hear you.
Yay! I feel like this is targeted. Why is it always me?
Probably, yeah, I don't think so. But, so not sure why that's happening, you know.
We are working on the mental health court application. I'm hopeful that we will be able to streamline it and make it easier. I know that one of the stumbling blocks has been in the past the request for records. In the current application, there is an order for the courts that will release the records. Those records are to be released to the defendant's lawyer, and the defendant's lawyer is to produce those records to our office so that we can evaluate the person and determine what's appropriate in terms of treatment. Unfortunately, there's been a disconnect, and some folks don't understand that I don't have access to anyone's treatment. I don't know, none of us will know where this person has received treatment, short of perhaps information that's come up during jail staffings. And so it's the impetus is on the person representing that defendant to find that information out. And I understand that there's a potential issue with that because sometimes we're dealing with people who are not willing to disclose and they don't have family members or other relatives who are able to provide that collateral information. A workaround for that is something that we've been working with behavioral health about, the possibility of a mental health assessment or a competency evaluation or a psychological evaluation. If any of those have been conducted in the past, in the fairly recent past, we're happy to review those in lieu of actual mental health records. And if there are ever any questions, please feel free to reach out. We're going to try to work with everyone and make the accommodations necessary to get people into treatment. We don't want someone to be without treatment as a result of our inability to get records.
I wanted to mention one of the things that we're working on is maybe how we can streamline our referral process, because right now it's based on emails between Texan and public defenders, you know. So I think recognizing HIPAA and client confidentiality, but I think there's some ways that either we can create a portal, we can create a Google form that is HIPAA compliant, that we can download the information. So I think there's some ways that we can streamline those things. And then also, because we spend a lot of time on that, that's, you know, everybody. So I think that will improve the process. And again, for attorneys, that will also improve, they'll know how to communicate with the team. So we're looking at that.
Real quick, Connie, I just wanted to mention that just so that everybody understands what the application is about. There was a change in law that happened about a year and a half ago that says that mental health court has to be voluntary. And so that's why the application is not extra. We're not creating extra work for people. for other attorneys to actually get someone into mental health court. There was a change in law that said that it had to be voluntary, and so we had to change both the misdemeanor and the felony mental health court so that someone actually has to volunteer to be in those courts. It's not like we can actually just someone's severely mentally ill and we just throw them in there. We can't do that anymore. There has to be an application, and that's why we're not creating extra work for anybody else. It's just a change in law that created that.
Ms. Body? Oh, hold on. Okay.
I just wanted to kind of piggyback on what Mr. Glass was saying. Before that new change in law, I was the contact and did all the referrals for mental health court. But now that there has to be an application, I can still be involved in that process if you need help with the application. But the defendant has to be made aware that they're being referred, which is very different than the process before. So we are still working on a team effort. Myself, Rocky's office, Donna's office, we are still working as a team to get defendants in the mental health court. So if you're having issues with the application, please feel free to reach out to any of us.
And most of you know this, these specialty courts have been created as therapeutic courts, therapeutic justice, much more of that non-adversarial process. So to help individuals engage with services. That's just to kind of piggyback on what's been said. This is amazing. And, I'm thinking, we've had, again, we did this seminar really for us locally, so for the Fort Bend County community. But as I hear you all talk, I'm thinking, oh, we should do this in the fall and expand it, to other folks outside of us, because this really is, sometimes we forget because we're so in the weeds of what we do on a day-to-day basis. But really, you can look at how things flow. It's not perfect, but yet how we really are starting to build that system where we didn't have anything several years ago. So if there aren't any questions, my suggestion is take a break and come back a little bit earlier, which would mean we would end 15 minutes early. Mr. Glass, is that going to be okay in terms of we still have the time, but just want to make sure. Is everyone fine with that? And then meanwhile, if you have questions, so basically don't log off, okay? But just
Quick, the CLE is actually created breaks, and that's why they do the 3.5 hours instead of the full amount, because the CLE requires breaks. So
sorry, there haven't been any breaks.
That's okay. With WebEx, you don't necessarily need breaks, but the CLE requires breaks, and that's why the 3.5 hours instead of the full 4 or 5 hours. But that's why.
So if everybody is fine with that, let's come back at 10:45 and we'll start the next session, which will be on the competency to stand trial and sanity evaluations, which is, again, kind of the next piece to this. And then we'll end it with the connection to services with Texana and Susan Savelli from Behavioral Health Services talking about, what they provide and which are critical services to keeping people out of the criminal justice system. Does that sound fine? So 10:45, everybody just mute yourself and turn off your videos. And we'll see you in 10 minutes or so. Thank you. Okay, we're going to give everybody a couple more minutes to get back on, maybe 5 minutes. So let's start it. We'll start our next presentation at 10:50. I don't see Dr. Martin, Dr. Todaro, and Miss O'Jury. Oh, there they are. And Dr. Martin. Is Dr. Martin on? I don't see her. Danielle, are you texting her? Dr. Todaro, can you reach out to Dr. Martin and
Yes, I can. She should be on.
yeah, it's usually. Oh, she is on. Just can't see her. So as we give everybody a couple minutes to just reconnect, one of the things, if you can maybe provide some feedback on, we're not doing a formal evaluation. Normally I do, and I collect data on it, but there is no formal evaluation. But if you can just provide us with feedback, like, did you find this useful? And especially if you think there's other topics that, you know, you would like to learn more about. You know, definitely looking at doing this in the fall, possibly as a hybrid between, you know, virtual and face-to-face, and really expanding it to folks outside of Fort Bend County or even other partners, and also including a focus, an additional focus on youth. So that would be great. I kind of mentioned briefly one of the projects that we're looking at. So we're in the process of writing a grant, something that I've looked at for the past 2 years, for children of incarcerated parents. So I am super excited about this. It builds on what we know. It's in partnership, of course, with the Sheriff's Office. It also builds on some of the work that we've done with the young children in CPS and the importance of attachment and bonding. It builds on our work around social determinants of health and reducing adversities, and the need for wraparound support. So just really excited about that project. It's a Department of Justice grant, so it's not an easy thing to get, but I think we have a really good chance at it. When we looked at the data in terms of the inmates that have children, and as you can imagine, a large percentage of individuals in the jail have children. They have multiple children, and a very large percentage actually have children under the age of 5. And I think Faye was reviewing some data the other day. You know, and it's always hard to see, you know, when a dad is booked into the jail, I think the next day after their child is born. I don't know what the issue was that, you know, definitely disrupts that attachment and causes some additional struggles for those families. So this is a really exciting project. So we know so many of our folks have family and children, and I think, my opinion, kind of thinking outside the box. You got to shift from individual focused services to family focused services. And so it's exciting to think about possibly moving in that direction. We don't have the money yet, but, or the project, but at least thinking through it. So with that, I'm delighted to introduce the next set of speakers. In this, again, kind of an issue that has been brought up. Mr. Glass brought this up, the individuals that are found to be not competent to stand trial. Some individuals found not guilty by reason of insanity. And this is something that we have developed over the years. There really was no capacity. I mean, the county would rely on outside providers, and we still have outside providers that, we cannot meet all the county needs, and there's some special cases that get referred to outside providers. But I'm delighted to say that we have really expanded our, capacity to really address these court-ordered evaluations around forensic issues with the competency to stand trial, the sanity, recently some certification evaluations, some violent risk assessment stuff, and a lot of bond conditions and psychological evaluations. So, so with that, who's going first? Dr. Tadara? Oh, Ms. Ojuri, thank you. So I'm going to turn it over to, we have Ms. Ojuri and we have Dr. Tadara from Behavioral Health Services and Dr. Martin from Behavioral Health Services. So go ahead. Thank you.
Good morning, everyone. My name is Overzina Ojuri, and I'm an attorney with the Mental Health Public Defender's Office. I'm actually the division chief. I have 4 lawyers that work underneath me, along with a licensed master social worker and 4 case managers. And I've been with the Public Defender's Office 11 years now. So it is exciting to see how, as a county, we have expanded and added and provided so many wonderful services. It's great to see so many faces, Jerome Ellis, and so many, even if it is virtual. I'm tasked with the duty, big duty, to talk a little bit, especially to the attorneys this morning, but maybe hopefully others that are on with us today to understand, when do you file a competency exam and when do you ask for a psychological examination? And so I want to start with a short video. I have some computer experts on the other side that are going to help me play a short video.
I think we're having some difficulty with the volume. Can folks, I don't think folks can hear it.
Thank you, Dr. Martin and Allison, for helping me with that. Competency. If you haven't seen The Joker, if you want to see a wonderful movie on mental illness, that's a perfect example. I went to see it with my family. I didn't know. I don't like to do the background information. I just love to go see movies. And the whole time I kept saying, this is mental illness in action. So The Joker. Incompetency. Article 46B03, incompetency presumption. A person is incompetent to stand trial if the person does not have a sufficient present ability to consult with the person's lawyer with a reasonable degree of rational understanding, or a rational as well as functional understanding of the proceedings against the person. And then B, we understand a defendant is presumed incompetent to stand trial and shall be found competent to stand trial unless proved incompetent by a preponderance of the evidence. So if we can go to the next screen or skip. Great. So first things first, meeting with the client. It is my recommendation that if you have concerns about whether or not your client is really getting it, is that you try to meet with them 2 or 3 times and plan on, if possible, I know it's not always possible, especially now using Securus and you're interviewing clients by video, but if possible, try to spend 30 or 40 minutes with them. Ask questions that are completely unrelated to the basis for their arrest. Listen to their statements. What are they saying? I've heard everything from I am Jesus. I'm President Obama. I'm President Obama. Listen to them. I have a chip in my brain. I had a client in my office this week. It was a case that actually got transferred to me from another lawyer in the office. So I hadn't got to meet with her. I wanted to meet with her. I met with her and she said, I was the first woman on earth. And I said, the first? She said, I am the very first. In fact, I own the earth. The earth is mine. On December 25th, 1965, I translated from being the first woman on earth to an infant. And I said, okay. And I actually began to, as I was talking to her, make notes for my affidavit of incompetence, and then went back through the file to realize she had already been evaluated and found not competent to stand trial. I think it's important when you're talking to your clients that you also listen to see, are they giving you any guarded statements? Are they refusing to tell you, especially if they're in jail, who's an emergency contact? Who can I contact? Where are you? Where's your family? Ask simple questions like, can they tell you their social security number? It's very important that you understand the total picture of the individual. What can they tell you? And don't just ask about the case. You got to ask more questions. You have to go in depth. You have to go off script, because that's when you're going to really get to understand who they are, where they are, and what they're thinking. If we can go to the next slide. Get medical records and get school records. If you can, if your client is able to, ask them to sign a release of information very early in the case. I usually preface that with, listen, I'm trying to get you out of jail. I'm trying to get your charges dismissed. I want to do everything I can. Can you sign this release of information? I'm going to get your records and I'm going to help. If you are working with a juvenile and you can get CPS records, those are the best. I would get those as soon as possible. CPS is usually very willing to give you lots of records, especially when you have a young person, 17-year-old that's in jail. They have wonderful records. When you're looking at CPS records, really review those to see if there's some issues with this person's, are they intellectually developmentally disabled? What is their intelligent quotient? What's their IQ? How did they do in school? Are they on the autism spectrum in addition to having mental health? And that's information that maybe can be tendered to the district attorney's office, and you may not even have to get to the point of incompetency. Make sure and call and speak with mental health treatment providers who will also be wonderful assets in getting records for you, especially if there are any case managers that are involved in their case through any other agency. Even counselors at school can be helpful. So look any way you can to make sure you get as much of the individual's history. I'm telling you that the doctors will tell you as much information as you can get for them is so helpful when they're doing evaluation, whether it's a competency or psychological or sanity. All of those evaluations are made easier when they have ample information. Next slide. Contact the jail. I love the jail. I know so many of those folks are like, oh, here goes Miss O'Jury. She wants the sun, moon, and stars today. I, like Dr. Almeida, am very much a tree hugger. In fact, I believe there's a certain probation officer who wanted to get me a shirt that said, bleeding heart tree hugger. So the jail is a wonderful source of information, as we've heard from so many of the speakers. Judge White, CIT. See if the client was treated for a mental illness in the jail. I would make that a first start. We know that you can get copies of those orders, but just pick up the phone, see if they'll give you information. I'm representing, they want to know. Contact our office, the Public Defender's Office. We attend those staffings weekly, and as part of the mental health team for the county, we are made aware of situations that have occurred in the jail. Find out while they were in the jail, were they on any medications? What medications were they prescribed? And how often were they taking them? If your client is taking their medications, especially they're any antipsychotic, they're taking their Referral every day at 100%, and they're still telling you that they're a Martian, we have a problem. So get with the jail. Also, when you're looking at jail records, really try to include and ask them for information, not just about mental health, but their conduct. Have there been any write-ups? Are they getting into fights with anyone? Have any of the other residents noticed anything? Maybe, their little ramen cup, they've, tore it up and did something unusual or done something weird with it, or putting it on top of their head. Find out from the jail any conduct observed, not just by the corrections officers, but also residents, because they will designate and make note of those things. In addition to that, you want to know where the client has been housed in the jail. Are they in isolation or padded cell? Are they part of general population? Are they in some other step down medical tank? There are levels of steps within the jail and placements. Some people need to be observed every 10 or 15 minutes. Some people that are suicidal are watched closely, even sometimes in less than 10 or 15-minute increments. So find out, because that's a good indication of the level or extent of the person's mental illness and of what the jail is observing. We talked about this odd behaviors notice, and then ask also to speak with any of the discharge planners. Andrea Fields is wonderful. She is a wealth of knowledge, and oftentimes she may know some information that even your client is not able to convey to you. She may know if they've come into the jail and they were living in a group home, and most of the time, by the time I speak to her, which could be within 5 or 7 days, she can tell me the name of the group home owner and or phone number. She's usually reached out to talk to them to see if the individual can return. She's usually really wonderful too about being able to give you the name of any case managers or social workers, CPS workers, family, friends, but use the jail as a great place to get information about your client, because it takes a lot of information to decide what evaluation you want to request. The family. Oh, we love the family. But you got to speak to the family when possible, because the family is going to tell you what your client's not going to say. Your client presents before you, and you know, based on meeting them face to face, that there's clearly a mental illness involved or some intellectual developmental disability. Your client is telling you, I don't have a mental health diagnosis. I've never had a mental health diagnosis. And you speak to the family and they say, oh, you know, Billy Joe was charged, I'm not charged, but Billy Joe was diagnosed with schizophrenia 15 years ago. And this is the name of his psychiatrist. And these are the medications he's been on. And, you know, they are a wealth of knowledge. In addition, if you can speak to group home managers and or workers, if the person lives in a group home setting, that's always wonderful. I speak to friends. I will talk to anybody who will talk to me about their clients. Speak to any contacts that know the client. So if someone calls me, I don't immediately cut them off. I'm like, hi, you know, I'm over Zeno Jury. How can I help you? And I listen to them because they may tell you that one nugget that you need to hear, that one piece of information that is so relevant. And then make sure you see if the family knows of other mental health professionals that have helped them. They may know the name of the psychiatrist, they may know the name of the medications they're taking, and they also may know if they have a case manager. Through Texana, people have case managers. Also through Takumi program, also under Texana, that may be another person to speak to. So anybody that knows about this client, you want to talk to them. Next slide. So I always like to, in addition, I've talked to my client, I've checked at the jail for information, I've tried to talk to the family, I've reached out to other resources. Then I'm going to do the fifth thing. I'm going to review the discovery, offense reports, and videos. It's amazing what you can see. When you're reading the offense report, what specific behaviors did the officers observe? That's relevant. Did the person put their head down the whole time? Was the person refusing to show their face, showing only their back? Was the person saying odd things? Did the complaining witness describe any odd behaviors or statements? He said the devil told them to shoot me, which we actually have a young man, unfortunately, that shot his mom in the head. She is alive. She is well. She doesn't want charges forward, but her son, being mentally ill, said the devil told him to shoot her. Did complaining witness tell officers that were called that their client, their son, their daughter, their husband, their wife is a person with a mental illness? What did they relate to the officers at the time of the arrest, which is so instant? And there are times they may have called for hopes of this person going to a hospital, but the level of their conduct rose to the level that they had to go to jail. But we need to know that information. And of course, watch police officers' dash cams or videos from inside the car. See what was going on with this individual at the time. Those things can often be the most telling. Those dash cams, especially if sanity is going to be an issue, can be extremely relative, because we know sanity is only dealing with that limited time. Were they sane at the time of the commission of the crime? So considerations. So after you've met with your client, definitely more than one time, Dr. Almeida talked about this. You know, someone may come into the jail and you're not quite sure how they're doing. It's rare that after a first meeting with the client will I file a motion for a competency examination. I always want to meet with them on more than one occasion for a couple of reasons. Number one, it may be that if they do get back on any psychotropic medications that they've been prescribed or are prescribed, they're in the jail, that there can be a clarity. They can completely clear up and be fine. So I rarely, if ever, file for a competency evaluation with meeting a client just one time. I want to meet with them a couple of times. I want to make sure when I speak to this client, though, that they can explain the basis for their arrest. Does it make sense what they're saying? Does anything stand out about their reasoning? I want to observe any odd behaviors when I'm speaking with the client. Are they looking around? Are they looking up in space? Is their head down the whole time? We had a client just this week who was twirling her hair, and literally in the jail room, this was a live visit, but she twirled around like a ballerina during the entire visit. She would not really answer questions. She would not make any eye contact. We are aware, because of speaking with the family, that she has severe mental illness, but you want to really pay attention to this. Are they talking in the air? Are they conversing with someone who is not there? Does their voice change? I've had instances where someone can be speaking to in a high-pitched voice, and then within seconds, it drops down to something. It almost seemed like something from really a horror movie. It can change. So you want to observe those nuances. And they may tell you, they may say, someone else is speaking to you today. This is actor two, and they may call themselves actor two, or Bill J is speaking to you. We're not talking to Billy today. We're talking to Bill J now. So we want to know, are they responding to any internal or external stimuli? And do they fully understand the role of all the parties? What I ask, please, I cannot implore enough, ask open-ended questions. Who is the judge? What is the judge going to do? How is the judge going to do this? What is the purpose of the district attorney? Make sure they can say, their job is to try to put me in jail, or to see that I'm convicted, or see that I'm found guilty. Open-ended questions. What is my job? What am I supposed to do? They may say, help me. How am I supposed to help you? Make sure they really, really understand that. Go back and review that rule 46B, so you know the standard. If the person cannot explain all the possible outcomes, I want to take this to jury trial. I didn't do it. I wasn't there. It wasn't me. He pulled a gun on me first. If they can't explain to you, I can plead guilty, or, oh, listen, can I get credit time served? I just want to plead guilty and I want to be out of jail. And they understand, yes, it's a conviction for assault or family violence. Yes, I know I can't carry a weapon. Make sure they can answer those questions. Talk about probation. What does it mean to be on probation? Sometimes, you know, we use so many terms and phrases and can assume that people understand that, but really talk to them. One of the things that I try to do, and part of that meeting with people several times, is making sure I can do any education. Well, if you plead guilty and you're placed on probation, this might happen, but I'm asking those questions about, why do you want to plead guilty instead of having a trial? What's the difference between a bench trial and a jury trial? Making sure they really understand all defenses. And then persons with intellectual developmental disabilities, remember that they are going to agree and acquiesce to everything. I had a young man who was very intellectually developmentally disabled, and he really couldn't understand between guilty and not guilty. And in that particular instance, I actually set up a meeting for the district attorney to talk to him, because he would get out and he would do the same kind of conduct. He would find vacant houses to go into, and he and his girlfriends would consummate their relationship in these vacant houses. And of course, the state was very concerned, but this little kid, clearly he didn't know the difference between guilty and not guilty, trial or not. He just knew he wanted to be out of jail. So be willing to look at all of those issues. So in that case where your client does not understand the process, they do not know what it means to be guilty or not guilty, or they say that they're a Martian and they couldn't have possibly done this. I had a young man who was able to talk to me. He said, Miss O'Jury, I went to AutoZone, and there was a vehicle out there, and the keys were in the vehicle and the keys were on. And I went into AutoZone and I waved at some guy, and I told him I need to take my car. And he said, yes, take your car. And I got into the car and I drove off, and the police officer stopped me. Actually, no, the car ran out of gas, and I got out of the car and waited for an officer who did show up and come. Well, of course, this wasn't my client's vehicle. So he was able to tell me that he took the car without permission. But the caveat was that he took the car without permission because he was an NSA agent. And didn't I know that he worked for the CIA? And I said, well, that's fine. And if you had to commandeer the vehicle, that's okay too, but I need documentation. Well, listen, this is all secret. They're not going to give you any records that I work for the CIA. They're not going to tell you that, Mr. Jury. I can't give you records, but they know, the police know, they know me. And I said, okay, that's great. So when you have those issues, you want to raise competency. When they don't understand the proceedings, when they can't give you a good legal basis for their conduct, you understand, make sure they don't. That's when you raise competency. Psychological is different. So, and the reason it's important that we're making that distinction, because oftentimes it's not the best use of time when a psychological is requested, when competency is at issue, because the doctor may meet with this person and say, oh my goodness, competency has to be raised. So now another motion, an order has to be filed. They have to do another evaluation. So they can't just make that jump. There's a process and procedures. Psychological evaluation. If I have a client that's competent, so I've already determined in speaking to them that I believe they understand what's happening, they are competent to stand trial, but you still have concerns, not as to their competency to stand trial, but you just have concerns about them as an individual. You want more information about this client. Maybe their charges are very serious. You're going to need some mitigation information. Maybe you just want to make sure that you're talking to them, because sometimes I want to know, maybe I want an IQ test done on this person just to make sure they seem competent. They know the role of the judge. They know they could be found guilty. They understand what they're charged with. But I just want to make sure that maybe when I'm communicating with them, I need to speak with them differently. If their case is going to go to trial, maybe I need to be prepared for how I break down information, how we break up the trial, whether we do a bench trial or a jury trial. And also, there are instances where I don't have any records. Family is not aware of this person ever having a mental illness, but I suspect in speaking to them or behaviors that I've observed that they may be a person with an undiagnosed mental illness. In those situations, I will ask for a psychological evaluation as opposed to a competency evaluation, which are two different examinations, two different reports, and provide different sets of information. And just a couple of quick practice pointers as I close out my portion of the presentation today. Just a reminder that you got to request a competency, even if you think your client's competent, if you're going to do a sanity. So remember that. Also, I'm assuming most attorneys are doing this, but in case there are some that are not, when you file your motion for competency, make sure you attach an affidavit. That, again, going back to the importance of seeing your client more than once. Put as much detail in that affidavit as possible. The doctors rely on that. They read them. Oftentimes I'll get emails or calls saying, what did you see? What did you hear? I try to put as much information. And listen, it's okay. Sometimes I am honest in my affidavit and I said, you know, I am not sure. At one minute when I'm speaking to the client, I think they are probably competent, but the next moment I'm not sure. Say that. I'm not sure if they're competent or not, or these are my concerns, but just outlay it. The more details you have, the better. Those things are very extremely important to the doctors, and also being available to speak with them about your observations. And then I know we think about another practice pointer that we think about how long the waiting list is for someone who has already been evaluated by the psychologist and determined not to be competent. An order is in place for them to be restored to competency, meaning that they're going to have to go to a state hospital. I know it's uncomfortable that people might sit in jail for a year or better before they can get to a state hospital, but I do want to encourage you to do it. I do that for a couple of reasons. Number one, I have a case I'm going to talk about as an example. I had a young woman, beautiful, striking, but her sophomore year of college, she had a complete breakdown in Austin and was found walking through the streets naked, was diagnosed with schizophrenia. Mom lived in the Austin area, asked her to come back down to Fort Bend County with dad, thinking it might be a little more calmer. This young lady was severely mentally ill. At one point, she literally took tar and took a wig and tarred it onto her head. So I meet this young woman when she gets charged with taking a bite. I mean, it's a small theft, class B. But I knew from the moment I met her that she was not competent. And so, you know, conventional wisdom might say, listen, plead her out, credit time served, and go on about your business. But something inside of me said, this young lady is severely mentally ill. I don't want her found guilty for this little class B theft because she's severely ill. So I did. I raised competency. Yes, it did net her spending some more additional time in the jail, but she did get to a state hospital and came back saying this young woman will never be restored to competency. Fast forward about 2 years after that period of time, she got pregnant. She gave birth to her baby at home, no prenatal care. Baby fortunately did live, but could have died because she gave birth to the baby alone at home in her bed. It was a tragedy, and she could have been charged with something very serious, child abuse, an attempted murder, because the baby almost died. But because it was on record that she was not competent to stand trial, because it was on record that she was not restorable to competency, it was helpful. The state was able to easy. The child did get immediately taken into custody by CPS in a safe home, and she is out. She's involved in a lot of services. I've not seen her back in the criminal justice system, but it helps tremendously. So I urge you just to file. The second reason I urge you to file is that many people that do go to state hospitals, not all, but a large percentage of our severely mentally ill that do have to go to hospitals to be restored to competency do come back restored, and they are so much the better. And many of them, not all, but many of them we never see back in our judicial system again. So I want to encourage you. And so just on a fun note, I've attached a list. I think this is going to be on the Behavioral Health Services website, but any great movies that you want to see if you're interested in mental health, Perks of Being a Wildflower, Shutter Island, Joker is the best, Concussion. Want to mention also Brain on Fire is excellent, where someone had a physiological disorder that did present as a psychological mental health disorder. So anyway, thanks for having me. Been wonderful. The training has been phenomenal as always, Dr. Almeida, and so grateful for behavioral health. And the last plug I want to throw in is that if you have any questions, please contact me. This is my work number and my email. Love to speak to anybody, any question. No question is too simple. I don't know everything, but I'll do my very best to try to find answers for you and help you if I can. My team is here and we're always willing to help. I'm grateful to all the lawyers and everybody that's part of my team here at the Mental Health Public Defender Office, and enjoy the rest of your training. Thank you to Behavioral Health, and they can do a lot. So if you have a special need for your client, they do a lot of individual therapy. They can tailor the counseling that your client may need, because we understand our persons with mental health, some of them, they can't go into a group setting with 20 people and really engage and understand why their behavior might not be appropriate. And so We love behavioral health. Thanks to everybody that's presented today. It's been wonderful. I truly enjoyed it.
Thank you, Ms. Ojuri. Appreciate it. So, Dr. Todaro.
Yes, thank you. Morning, everybody. My name is Dr. Danielle Todaro. I'm a licensed psychologist here with Fort Bend County Behavioral Health Services, and I'm going to be talking a little bit more about competency to stand trial evaluations. Ms. Ojuri covered a lot of this information, so I may go through some of these slides more quickly to address some of the other ones. So as she mentioned, the Texas Code of Criminal Procedure 46B is the statute that defines competency, what needs to go into the evaluation, restoration, and things of that nature. And so the two areas, of course, that we are going to be looking at in terms of evaluating a defendant for competency is whether they have the ability to consult with their attorney in a rational and reasonable manner, and or whether they understand their charges and the potential consequences, both factually and rationally. And when we're talking about rationally, we're talking about, can a defendant take the information that they do know about their charge and the legal system and legal options and apply it directly to their case without any interference from any mental health or intellectual disability. So just a couple of things to keep in mind about competency, that any defendant that comes to us, unless they have been deemed already incompetent by the court, is presumed competent to stand trial. So that's where we're starting at with every defendant when we evaluate them. Like the quote here on the left says, it's really important to keep in mind that incompetence and mental illness are not synonymous. So we can have defendants that may be psychotic, may be experiencing mania related to like a bipolar disorder, may be depressed, may have an intellectual disability, and they can still be competent to stand trial. So the two are not necessarily linked to each other. Something else that's really important to keep in mind in terms of competency is a here and now issue. We are talking about today, presently, what capacities does the defendant have or not have. We're not talking about at the time of the offense. Dr. Martin is going to go into sanity evaluations in a minute, and that's where we will focus on that. And of course, if we do have a defendant that has any deficits in their ability to understand their case or work with their attorney, those deficits, those difficulties need to be connected to a mental illness or an intellectual or developmental disability. We can't determine that an individual is incompetent just because they are unwilling to work with their lawyer, because they have a difficult personality. It has to be connected to one of those two things. So in terms of the components of our evaluation, so just an FYI, on the Behavioral Health Services website, which will have a link at the end of the slides, we have copies of motions and orders for competency evaluations, sanity evaluations, all the evaluations, forensic evaluations that we do here. And so you know, any attorneys in the audience are free to use those when filing, you know, for different evaluations in your cases. So when we get an order for a competency evaluation here at BHS, typically the way we go about evaluating a defendant is through an in-depth clinical interview. Right now, majority of those are done telehealth. We can do them in person if necessary. And we focus on a little bit of the defendant's backgrounds. We want to know just a little bit of their social history, but really with an emphasis on any mental health history, or if they have an intellectual disability, their academic history, treatment, things like that. And then really the bulk of our evaluation is asking focused questions that's going to tap into the competency capacities that are outlined in 46B. And I'll talk about those a little bit more in a moment. In terms of psychological testing, we don't often use it in competency evaluations, but we can if necessary. So if we need to assess somebody's intellectual abilities, we can do IQ testing, or if we have an individual that maybe there's concern of dementia or Alzheimer's, we can do some cognitive testing in those areas. We may do testing to kind of help confirm or rule out a mental health diagnosis, especially if we don't have much information about the individual's history. And then, of course, if we're suspecting malingering, so if we think a defendant may be faking their presentation, exaggerating their presentation, we have concerns, we do have some measures that can help guide us in making that determination, so we may use those. In some of our evaluations, not necessarily all of the competency evaluations, but if we are going to make an opinion that we think a defendant is incompetent, we will generally add in a section on our opinion on malingering, just to let the court and all parties know we've thought about it, we've looked at it, and we think that this person does have a genuine mental illness. That'll help kind of inform our opinion about incompetency. Of course, if we do think a defendant is faking or feigning their presentation, we will of course include a section on malingering to let the court and all parties know that that's a clinical opinion as well. Luckily, that doesn't happen too often. And then of course, the main part of our report is our opinion on the defendant's competency to stand trial. That's typically at the end of the report where we opine on that. Ms. O'Jury did a great job covering records, so I'm not going to cover this too much, but records are important. With competency evaluations, I think the most important records are any mental health records from any source, educational or academic records, especially if we have an individual that we're concerned about intellectual disability, and then any other collateral sources. We'll reach out to the jail, to the DA's office for jail phone calls in the event that we think a defendant might be malingering, or reach out to friends, family, children, spouses, if necessary. And here within BHS, we do have access to the jail electronic health records, so we are able to access those records for folks that are in custody or have come through custody. So that's not necessarily something we need attorneys to provide, because we can access that. So in terms of the issues actually evaluated when we're doing a competency evaluation, so these are the 6 capacities straight out of the 46B statute that you will find in one of our reports. And our reports really just mimic the statute in terms of how our competency section is laid out. So when we're with a defendant, we're of course going to assess their ability to rationally understand the charges against them and any consequences that may be associated with those charges. We're going to assess their ability to disclose facts, events, information surrounding the allegation and their arrest. So for defense attorneys, just keep in mind with a competency evaluation, we're not trying to determine guilt or innocence or anything like that. And we don't go extraordinarily in depth in this section. In a sanity evaluation, we definitely do. But we do just need to check with the defendant to see, do they understand kind of what the basic allegations are, the basic facts, the basic factors related to their arrest. Then we're going to assess their ability to engage in a reasoned choice of legal strategy, so their kind of decision-making capacity, their understanding of courtroom criminal proceedings in general, their ability to exhibit appropriate behavior in court, and their ability to testify if they decided to do so. Additionally, we have to assess these factors too, which are also coming straight out of 46B. So we have to identify, of course, if the defendant has a mental illness or an intellectual disability and what that diagnosis is. We have to talk about how long we know that this diagnosis has persisted and will it continue for at least the next year. Number 4 here, of course, speaks directly to one of the prongs of competency, in that we're going to assess the degree of impairment and the specific impact that the defendant's mental illness or intellectual disability impacts their ability to engage with counsel in a rational and reasonable manner. So this is a very important factor that we're looking at. And then we talk a little bit about medications. Is the defendant on medications, or are medications needed to maintain their trial competency? And will the medications have any impact or effect on their ability to proceed in court? We definitely like to talk about our folks that are in custody. We have access to their level of compliance with their medication. I think Ms. O'Jury referenced that earlier. So we always make sure to include if they're taking their medications and they're still symptomatic, or if they're not taking their medications, are important components of the report. So then, of course, the part that I'm sure everybody flips to first when they get one of our reports is the opinion on competency. And so we structure that at the end of our evaluations after we've provided all the information. Here in Texas, an evaluator has to provide an opinion on whether we think a defendant is competent or incompetent. Now, We can say that we're unable to. If we are unable to, if we don't have enough information, we can say that we're unable to form an opinion and have to provide an explanation as to why. However, I would say in the overwhelming majority of the evaluations that we do at BHS, we are able to provide a clinical opinion in most competency evaluations that we do. Now, if we are opining that a defendant is not competent, we have to make sure as evaluators that we are not basing that just on the defendant's unwillingness to meet with us. And unfortunately, that happens very frequently where defendants just don't want to come and talk to us, or they'll cut an interview short. So we can't simply say, well, they didn't meet with me, so they must be incompetent. Now, we can render an opinion on somebody's competency if they don't meet with us. And by statute, we have to provide a report with to the court since it's court ordered. But we can make opinions based on collateral information, medical records, mental health records, consulting with other sources as to what we might think the person's competency is. And if we are finding a defendant not competent, we are also required to put in the report our thoughts, our opinion on whether they can be restored in the foreseeable future. And so in terms of 46B, that basically just means within the time frame allotted by the statute for how long that individual will be at the hospital receiving treatment. And that varies based on if it's a felony offense or a misdemeanor offense. I feel like in the majority of the evaluations we're generally able to make an opinion that somebody can be. However, there are situations such as if somebody has Alzheimer's or some sort of dementia where we know their prognosis is not very good for them being able to retain the education that they'll get at the hospital, we may say this person is likely not going to be restored. Or if we know already from the person's history that they've been for multiple prior restoration attempts and they haven't been successful, we may say we don't think that this person can be restored. But that opinion has to be part of the report. Just a fun fact, there's some photos from two of the state hospitals that many defendants go to. The top is Austin State Hospital and the bottom is Rusk State Hospital. There are certain facilities that folks can go to for restoration. So in terms of restoration, obviously the purpose of a competency evaluation and getting an opinion on competency is to, if the person is incompetent, get them into treatment to restore that competency so that they can take care of their legal charges. That's the ultimate goal. Or if a person is absolutely unrestorable, to make notice to the court that that's likely the case. So once a person has gone for restoration to the hospital, then the hospital will report back at a certain point in time whether the defendant has attained competency, which if they have, they return to custody and hopefully continue with their case very quickly. And if the determination from the hospital is that the individual is not competent, then decisions will have to be made in terms of, will the state drop charges against the individual, or do they meet requirements for civil commitment, either with or without their charges pending, or they need longer term treatment in the hospital. So that is my section on competency. So I'm going to turn it over now to Dr. Martin to talk more in depth about sanity evaluations.
Okay, I'm going to wrap up the presentation and focus on criminal responsibility or sanity evaluations. I'm hoping everyone can see and hear me okay. So sanity evaluations they don't happen or they don't occur as often as competency evaluations, but every once in a while we will get orders to conduct them. This is Andrea Yates, who was a former Houston resident. She was found NGRI in, I believe, 2001 for drowning her 5 children. Oops, let's see if I can get this to work here. Okay, so as with some of the other evaluations that we talked about, the sanity evaluations really has to do with 2 different codes. So the Texas Criminal Code 46C really outlines kind of more what happens after someone is found NGRI, but really the Texas Penal Code 8.01 is really what defines it. And so it says that it is an affirmative defense to prosecution that at the time of the conduct charge, the actor, as a result of severe mental disease or defect, did not know that his conduct was wrong. So essentially what that means is that the defendant, of course, did the actual offense, but because of their mental illness or of their developmental disability, they were not able to understand right from wrong. And this particular penal code only considers the cognitive prong, not the volitional prong. So meaning that in order to kind of make a determination on that, we don't have to take into account whether the defendant was able to conform their behavior to the letter of the law, which that's a little different because actually in juveniles, that is something that has to be considered. So for adults, it's the cognitive prong only. So when trying to figure out if a particular defendant might need a sanity evaluation, all of these particular things should be present. So the individual must have either a serious mental illness or a developmental disability, or you as the individual's attorney may be concerned about that. So both Ms. Ojeri and Dr. Todaro did talk about, maybe this person does not have an established diagnosis, but you might have some concern based on the individual's behavior. Also, the client must be competent to stand trial, which is something that Ms. Ojeri also mentioned. In order for us as the evaluators, in order for us to conduct a particular interview, the person has to be at least generally stable. We cannot interview them if the person is completely unmedicated and completely unstable at that time. Also, your client has to be willing to admit to the offense and discuss it in detail. Both Dr. Todaro and I have unfortunately had some clients where we go to see them and before we even get the words out on explaining what exactly the purpose of it is, they immediately shoot us down and they say, no, I'm not doing that. And so we have to stop the evaluation or the interview at that point. And we are not able to render an opinion on sanity if they choose not to admit to the offense. So that is something very important. They have to know that they are admitting to this particular offense and discuss it in great detail. So most of these also should be present when trying to figure out if a particular defendant might require a sanity evaluation. And so your client should understand the potential outcome of pleading NGRI and exactly what that means. And that really also speaks to their competency. Do they really understand kind of what exactly does it mean to plead NGRI and possible outcomes? That's something that we go over when we conduct the competency evaluations as well. Also, as the attorney, you have reason to believe that the client's mental illness was in an active phase. What that means is that they were symptomatic and that their symptoms were very much involved in their actions, in their resulting actions in the particular offense. And then also, like I said before, their mental health condition at the time when we're going to see them is generally stable. So as Dr. Todaro mentioned, in contrast to competency to stand trial, sanity assesses the individual's mental state at the time of the offense. So it is more so, it's definitely retroactive. So we're looking at what happened at the particular time and immediately around the time of the offense. If you're thinking as an attorney, if you're thinking that maybe your client might need a sanity evaluation, you don't need to file a motion for a competency evaluation or a psychological or mental health. You can kind of think of a sanity evaluation encompasses all of those factors. So the sanity evaluation, we're going to make sure that the person is competent before we even go forward and interview that particular person. And then in terms of, the components for a psychological, we're also going to make sure that they do meet criteria for some kind of mental health disorder. Usually it's going to be a serious mental illness, so a psychotic disorder, a major mood disorder, or a developmental disability. If a competency was done at a previous time by an expert, 46C also says that that same expert can conduct the sanity evaluation. And again, sanity is a legal decision that's ultimately decided by the court. We do provide our opinion, of course, and we provide evidence that supports that opinion, but the judges, they make that final decision on the defendant's sanity. So in conducting the evaluation, the sanity evaluation to me, and I always say this to other evaluators and even interns that we have in our office, that sanity evaluations are among one of the most complex and comprehensive type of evaluations that we do as forensic evaluators. So 3 major types of information that's needed just in general. It's historical information about the defendant's background. That's going to be relevant to forming an opinion about the particular mental health disorder or developmental disability. We're also going to collect information on the individual's current mental status, so which may be related to the defendant's mental state at the time of the alleged offense as well. And then, of course, observations of the defendant's mental state and behavior around and at the time of the alleged offense. So actually going into the different parts that you'll actually see when you read our reports is that we're going to do an in-depth clinical interview with the defendant. And that particular interview is going to include background information with a major emphasis on mental health history. We're also going to, in the sanity interview portion, we're also going to ask them very detailed questions about the offense. I've had defendants that get a little bit exasperated with me because I will ask them very detailed questions about every single action that they take. And those questions are about events preceding the offense, about the actual offense itself, and then also their actions and their perception immediately following the offense. Psychological testing, we will possibly, but not always, conduct psychological testing for the sanity evaluations. If we do, they're more than likely going to be malingering measures. As you can probably guess, there may be a lot of defendants who try to malinger or fake their symptoms so that they can get out of, possible prison time. And so malingering is something that we do have to assess for. It's very pivotal that we assess for that in the sanity, unless there is unequivocal evidence that this person's mental illness is genuine. Now, we do also have, though, individuals that will have a genuine mental illness, but they still might try to malinger certain symptoms. I've also had those types of defendants. So sometimes we still have to do that testing. And then we also might do some mental health measures to confirm, conduct a mental health assessment to confirm the diagnosis if we don't have any psychological records to kind of confirm that. I'll provide an opinion on malingering. The competency, I'll do it one of 2 ways. If there's no recent competency evaluation and I have no doubt as to their competency, then I'll just do a brief competency assessment just to make sure that they have some of those pivotal capacities. If there's no competency recently done and I do have doubts about that person's competency, then I will do a full interview. And depending on how that interview goes, then I may or may not move forward with the sanity interview. And then we'll provide clinical impressions and then, of course, the findings on the defendant's sanity. So for the records that are needed, sanity evaluations We need a large amount of records. And I know there are some DAs on here. I know that I've pestered Donna and Leslie for a whole host of these things. And I really do review all of them. So sending them to me is not in vain, I promise. So I look at all the offense reports, officer dash cam, body cam, detective interviews with the defendant, if any, 911 calls, and then jail phone or video visitation calls. All of those things are very, very important to understanding the individual's mental state at the time and around the time of the offense as well. And then, of course, psychiatric or correctional records to, again, confirm that diagnosis, or sometimes we'll use correctional records to confirm possible history of malingering. And then, of course, contact information for collateral sources. This particular information will also help us understand the person's mental state at the time, family members, friends, individuals present around the time of the offense. I'll either speak to them directly, or sometimes some of the other collateral information will have statements from those individuals. So I'll review those and also include those in the evaluation. So informing the opinion, there are 4 major issues that we evaluate and that we address in the final parts of the report. And that's whether the defendant has a severe mental disease. So that means a serious mental illness, like a psychotic disorder or a major mood disorder. If they have a severe mental defect, which is an intellectual or developmental disability. We'll look at whether at the time of the offense, that particular mental condition was in an active phase or not. So whether the person was symptomatic, they were having active symptoms. And then we'll make a determination on if, as a result of the severe mental disease or defect, the defendant knew the act was wrong. And then for each of these issues, we'll highlight evidence for each of them. Some key elements just informing the opinion in general. In more complex cases, there actually might be evidence for both sides, whether the person knew or did not know the wrongfulness of their act. And in that case, make a determination. We'll explain exactly the evidence that goes to both sides, and then we'll make a determination or an opinion for the side that holds more weight. In general, things that we're going to look at, attempts to avoid detection by law enforcement, that about 80 to 90% of the time does mean that the person understood their wrongfulness. Now, sometimes the person might be trying to run away from law enforcement because they think police officers are aliens or Jesus Christ. And so that obviously we have to evaluate in another context or in context. Evidence of planning the offense. We're looking at motives for action. So are they reality-based or are they bizarre or psychotic? We're looking at the defense account of the offense. At the time, is it bizarre or is it coherent? We're going to look at evidence of active symptoms of mental illness that likely impacted their perception and their behavior. We're also going to see, any behaviors or statements that indicate remorse. And then we look at legal versus moral wrongfulness. Sometimes you'll have defendants that can appreciate legal wrongfulness, but they will not be able to appreciate moral wrongfulness, which, if I'm not mistaken, that was the case with Andrea Yates. She knew that what she did in the eyes of the law was wrong, but from her perspective, she thought that what she doing was right to save her children from evil or the devil. Just really quickly, substance abuse in the insanity defense. Being under the influence of a substance alone does not satisfy for the insanity defense, because honestly, pretty much almost everyone in the jail, I think, would be able to satisfy for the insanity defense, because it is a voluntary action. But if there is a history of or suspicion that substance use might have worsened the symptoms of a pre-existing serious mental illness, then the insanity defense can be substantiated. And so, of course, the way that we determine that are by reviewing all of those records that I mentioned before. And we take a very in-depth look on the person's substance abuse history as well as mental health history. So I know I went through some of the last slides a little bit quickly, but that is what we have in terms of sanity evaluations and competency evaluations. And also we really appreciate Ms. Ojuri also giving us the insight in terms of the defense counsel side. This is my contact information and Dr. Tadaro's information and our website here. If you have any questions or anything, you know, we are more than willing to talk with anyone, to consult, talk about any cases that you might have. And with that, I'll stop sharing my screen and I'll give it back over to Dr. Almeida and see if we have any questions as well.
Thank you. That was excellent. And Dr. Martin, Dr. Tadaro, and Ms. Ojuri, if you could actually maybe put your emails in the chat box, then you know folks have it and can reference that. We will post the materials. I just wanted to, excellent presentation. The malingering issue is so important. Dr. Tadaro and I had a case, and made us aware, learning experience. You know, I really thought this person had IDD history, special ed, IDD records, family records, you know. So I'm thinking mild IDD. However, when he started writing with the wrong side of the pencil because he didn't know which was the right side, you know, I was like, oh, okay. And yeah, he was clearly malingering. So I learned a lot about, you know, what to, how to look at that, but important to look at. Thank you. That really was excellent. I wanted to mention one thing. We have a court orders, BHS court orders at Fort Bend County, tx.gov. I think that's it. Allison can put it on the chat box. Most of the time there's an order. There are a couple of times when there's a docket entry. If there is a docket entry, please make sure that someone in the court faxes it to us, because there is not an automated, if there's an order, you know, we'll get it from the district clerk or the county clerk's office, right? Because it's e-filed. That if it's not, the docket entries are not, so please make sure that they get to us. We've had some experiences, not recently, but you know, where somebody shows up for an evaluation or calls us and we've never gotten the order because it was on a docket entry. So doesn't happen too often, but if the judge makes a notation on the docket entry, please make sure it gets to us. So I also promise that next time we do this, I'm going to put the connection to services as the first thing we talk about. Because, you know, I know by now people are tired, but it's been amazing. Thank you, all the presenters. This is just really, really good information. We tried to record it, but we had some technical problems. We'll do better next time, but we will have the handouts. And also the connection to services is probably the most challenging. So now we know they have a mental illness. We know this. Now what do we do? You know, what do we connect them to? We know that often they need so many services, and Ms. Body talked about that, you know, housing, transportation, food. We know that, you know, benefits, healthcare. Yet we have limited services we just do. This is a very difficult population. Even when we have housing funds, because they have a legal history, we can't get them housing, or we can't get them jobs, which we know are critical. So many challenges with this population. So Texana, the local mental health authority, of course, is a key provider of services to this population. And we partner with them on a particular project that came out of Senate Bill 292, which is a enhancement of their assertive community treatment team. And I'm sure Julie's going to talk a little bit about that. And then we also have Cherie Steinberg, who's the director of crisis services. And then Susan Savelli, who's been with behavioral health services for maybe almost 6 years. Yeah. Okay. Thank you, Susan, for reminding me. We actually started that program, which many of you know as our recovery and reintegration program, which right now is just Susan, that we funded out of the 1115 waiver. And, you know, she's been able to partner with several of you, but also to provide some unique services that truly fill in the gaps until we can get the individuals connected to other services or when they don't qualify for other services. So with that, and thank you all for hanging in there a couple more minutes. I know people are tired, you're going to get CLEs. And even more importantly, I really do hope that this was beneficial and everybody learned something new. So I forgot who's starting from you all. Okay, Julie, let me unmute you. Well, okay, go ahead, Julie.
All right, am I unmuted now?
You are.
Okay, great. I do have a slideshow. I'm gonna, let's see if I can share. This will,
We're all so high tech that we can share. Remember a couple months ago, it was like, what do you mean share?
okay, so are you all able to see that?
We can see it, Julie.
Okay. So I'll first introduce myself. My name is Julie Oladipupo. I am the team leader for the Assertive Community Treatment Team here at Texana Center. We are the local mental health authority. I will move through the slides. I'm going to go give you all a brief overview and introduction of what is assertive community treatment, and then how does that tie into jail diversion under the Senate Bill 292 grant. So let's see, for the assertive community treatment, just a brief overview. It's a nationally utilized, it's an evidence-based practice, and it's a service delivery model. So it's not necessarily like a therapeutic technique or anything like that, but we do utilize a team-based approach where it's multidisciplinary. So I have case managers, you know, from different backgrounds with different skills and strengths. We have a peer specialist, we have a recovery coach. The RN, we do have an RN that we can utilize for some of the services. And we do coordinate with the psychiatrists. Yeah, and then we work also collaboratively with our supported employment team. So that's kind of all the different disciplines that's included in the team. Our service that we do provide falls under the psychosocial rehabilitation services. Just to narrow that down, it's a focus on illness and or symptom management and recovery skills, helping the client to develop social supports. We address their housing and employment barriers to the best of our ability, provide them with training in independent living skills, and do a lot of connecting to community resources. The other unique piece of ACT is that the services are provided in the community. We go into the field, we go into the community to where the clients are living, whether they're in their own home with family members, group homes, some that are homeless and bouncing from place to place. We meet them where we can find them. And, you know, we're really out there trying to maintain the connections and keep the person engaged in services. We provide an average of 10 to 20 hours of service per client per month. That's including the psychosocial rehabilitation, housing and employment supports, medication management, nursing, and peer supports. So that's what the ACT team does, and what ACT as a service delivery model is. So I'll jump right into the jail diversion Senate Bill 292 overview. This is a partnership between Texana Center, Fort Bend County, and Fort Bend Regional Council. We provide services and resources to the Fort Bend County residents who are diagnosed with a severe mental illness and who are also involved with the criminal justice system. The aim of the project is to help reduce the recidivism and where possible divert folks from the jail into mental health treatment. And we do have some specific eligibility criteria. They're not extensive, but we do utilize this criteria. We focus on those who are truly Fort Bend County residents versus someone who has maybe primarily lived in Houston or another area and passed through Fort Bend County, got arrested, and is now in our jail or was recently in our jail and has a mental illness. So, you know, really want to focus on those who are and have been living here in our community and are residents of the community, but who need the additional supports that could be provided to them under this jail diversion program. The client must be diagnosed with a serious mental illness, which would fall under any of the schizophrenia diagnoses, bipolar disorder, or major depressive disorder. They must have been incarcerated within 12 months prior to the referral. So if they were released from custody, you know, 6 months ago, and you know, they're now on someone's radar and they could still potentially meet criteria. So ideally, we like to connect with them while they're in jail, and we then can bridge that gap, make sure that they're engaged in services prior to being released from jail. But sometimes we do go back and have referrals on individuals that have been in the community already, and we can still engage them if that's appropriate. The last criteria is that they're determined by ANSA. The ANSA is our Adult Needs and Strengths Assessment. That is our tool, evidence-based assessment tool that the state requires all the local mental health authorities to use to determine the client's essentially their level of service, what type of services they are eligible for. And the ACT services fall under what is a level 4 under the ANSA scoring system. So we literally administer that assessment and put there's not sure exactly how many, but maybe approximately 40 or 50 items that are scored, and all of that goes into the program automatically calculates for us. So we don't really have any control over whether the person is going to have the scoring to meet ACT services. But we do know that certain criteria tend to end up at that level, which are recent hospitalizations, more than 1 or 2, and lengthy hospitalizations within the last year or 2. So someone that maybe has been in the state hospital for 3 months, 6 months for competency restoration or simply for treatment, those clients will typically have an ANSA score that puts them into ACT services. So those are the diversion criteria. Once we know that those are met and we bring someone into the program, some of the things that take place or how things take place is listed here on the process. We do have a therapist, an intake therapist, who can assess that eligibility and conduct our clinical intake prior to the individual's release from jail. This way we know, okay, hey, you're eligible for our services, and as soon as you're released from jail, usually within 24 to 48 hours, my team ensures that they appear at the clinic, and we do the administrative part of their intake and get them scheduled for their psychiatric evaluation and immediately begin working with them in the community. We have a recovery coach. That position is funded through Fort Bend Regional Council, but the recovery coach does work on the ACT team, and that person is responsible for supporting those individuals who have substance abuse services, and they need maybe connection to Fort Bend Regional Council for outpatient services, doing connection to community-based services such as AA or NA meetings, and if possible, connecting them to Fort Bend Regional Council if they may need to be assessed for a higher level of care related to substance abuse, such as an inpatient treatment or rehab. So we really love having the recovery coach on board. It's a really great tool. Some clients may not be at the point of acknowledging their substance abuse problems, but with some ongoing interaction with the recovery coach, different options can be presented to them as, ways for them to look at their substance abuse and how it may have been impacting their behavior and or their mental illness. And hopefully they may agree to get some help in that area. Our jail diversion coordinator is Martisa, or she goes by Marty Smith. She's the liaison between us and Fort Bend County. So she, along with the intake therapist, goes into the jail to do some preliminary screening on referrals to see if the individual is likely to meet the criteria for participation in this program. She does a lot of the psychosocial rehabilitation and case management for individuals who are in the community enrolled in the program, and will participate in the court proceedings with those individuals who are in the mental health courts. She will be there representing Texana on their behalf to provide information, communicate, and advocate and support the client when they do have their mental health court appearances. As I mentioned previously, the psychosocial rehab services are provided by the team at large. A couple of additional things that are offered under this program that is above and beyond what would normally be available to an ACT team client. We are able to utilize Fort Bend Transit as part of the grant. We directly connect with them and schedule the clients for their trips on transit versus them having to go through the typical phone call and scheduling if there's availability. So that's been essential in getting clients to and from the clinics when they do have to go in to see their doctor, or to and from probation for those appointments. So that's a really key piece, is the transportation service. We also do have funding for emergency transitional housing. Perhaps someone's been in the state hospital and the jail, or both, over the course of an extended period of time. They may have received Social Security disability benefits in the past, but maybe they were terminated due to the length of incarceration, or very likely are eligible for disability benefits but have never applied. They don't know how. So they don't have any means of supporting themselves. So we look at those cases, and if the person's being released from jail and they need some temporary housing assistance, we can provide some funding for that. It's usually in a group home or a residential, like a group living situation, boarding care type home, and that would be temporary. We look at 3 to 4 months, maybe 4 to 6 months at the maximum end, assuming that we've gotten their application for Social Security filed and we're waiting on that approval, hopefully. Or if the client is at a level that they're able to probably reintegrate into the community and go to work, and we're supporting them towards employment, then we hope that within that time period they've been able to secure employment and can then begin contributing and eventually take over paying for their own housing. And we've had that occur on a few occasions, so we see it both ways. We do also provide some flexible funding for provision of their basic needs. Like I mentioned, imagine an individual that's been incarcerated, been in the jail and or the hospital system, and they're walking out of the jail with the clothing on their back. They don't have anything. So we try to keep a supply here of basic hygiene items and basic clothing items, t-shirts, and shorts or pants that at least can have them with some semblance of clothing and their basic hygiene and other needs, if they're going to a group home, especially those who maybe are able to be released into their family or so forth. Usually the family will be supplying those needs, but we do have some flexible funding, which is good, because often these clients are needy in that area. And the last point on this is the referrals into this jail diversion project are accepted from any of our collaborative agencies. So that's just basically anyone that's on this webinar today, and as well as any professionals in the community at large. if there's anyone that you all know of who has been in jail and who does have a serious mental illness that you think might be eligible for the program, are welcome to refer them to us. And then we'll take it from there as far as assessing, looking at background, hospitalizations, how many they've had, when they were, and trying to determine if, they're going to go ahead and meet the eligibility criteria. So that's a quick summary of the process. And this is the contact information, and I can also put it in the chat as far as the email addresses. And I'll be happy to email this slideshow over so that it can be distributed as well. So you have my contact on there, Martisa Smith, I mentioned Marty as our jail diversion coordinator, and then my supervisor, Cherie Steinberg, is our crisis services manager. So that's a quick overview of those two things. Is there anything else I needed to cover?
No, thank you so much. I wanted to mention that a little bit about Senate Bill 292 and how this jail diversion project got started, because this really is one of those projects that requires a collaboration between the county and the community mental health center. So sometimes those forced working relationships actually make us more successful in leveraging funds and also on building some enhancements to programs. Kind of what you see here is an ACT team that's been enhanced with some wraparound supports, which we've actually been trying to do with our recovery and reintegration program. Susan will briefly talk about. But this program actually requires a county match, so that then the community mental health center can leverage some additional state dollars. So I just always kind of like how things get started and, how we try to make sure that we're working together on those things. So I just wanted to add that. Cherie, are you going or are we going over to Susan? And I know we only have like a couple more minutes, so.
I'm gonna throw in a couple of pieces of info on Cherie's behalf. Which is primarily in reference to our crisis center and how that ties into some of the jail diversion and the criminal justice that we're talking about today. So with the Senate Bill 292 project, we have included the crisis center as an option. So someone that maybe is coming out of the jail and we've not been able to determine an appropriate housing arrangement for them, or we maybe want to spend a little bit more time assessing and stabilizing them before they're in the community at large, we can step them down from the jail often into our crisis center on either the extended observation unit, which is an involuntary hold under an emergency detention order, or they could voluntarily go to our crisis residential unit, and that would be them agreeing to do, admit into that program. And they could be there for, usually maybe 3 to 5 days. That allows my team to go over and begin immediately interacting with and assessing and coordinating discharge planning from the crisis center into the community. So that's a large part of how we connect the individuals to services and get them engaged. Sometimes using that step down into our crisis center.
Yes, thank you, Julie. I was muted before I can unmute myself. And I think Julie really covered it. I did send Connie a couple of Texina brochures, one on our crisis center and one on just our outpatient behavioral health clinics. So she can share that with the group for information. And a lot of our stuff, that is not crisis services and even voluntarily going into the crisis residential unit for a stay, someone can start calling our Texina Center crisis hotline. And even though if someone's voluntarily going to the crisis residential unit, they can get assessed. An MCOT person will assess them to make sure it seems like a good fit to voluntarily go into our crisis center. And I do have to say, with as difficult as everything has been with COVID, our access to clinic services has become even easier because there are still a lot of clients that are wanting more electronic type services, which means a lot of the staff are in the office and not out driving to people's homes. They still are doing that, but they're able to handle intakes on demand, all of that type stuff so much more easily. And usually the easiest way to get into a clinic is just calling those clinic numbers. Those are on the brochures that Connie can share, and I'll type in, I mean, Julie just shared my contact information, but I will put it in the chat box too.
Thank you. In the Texana Center crisis line is 1-800-633-5686. So I'll just send that out. Last but not least, Susan, thank you so much. Also, Susan is still not in her home after dealing with a very tragic outcome from the freeze, which, you know, has unfortunately impacted so many folks. So she's been living in a motel.
Yes.
With her adult son, right?
Who has a mental illness. So
Yeah,
that's all kinds of
mental illness. So that's him coming to work every day. So Susan.
Yes. So
to wrap it up.
And since we are so close to finishing this seminar, I'm going to hopefully try to share my screen to show you a little bit about the recovery and reintegration program here with Behavioral Health Services. So give me a minute because I've actually never shared anything. So hold on. Might need some help.
Okay.
Let's see. Oh, all right, hold on just a second. I have somebody coming in to help me. I want to share that there. The share. Okay. Okay, so it's up. Okay, so this is our service fact sheet that tells you a little bit about recovery and reintegration. We offer clinical forensic services for adult clients with complex issues, and that would be the severe mental illness, possible substance abuse, which is most likely with our clients. I think about 95% of those that we treat here have co-occurring disorders. In addition to possible IDD issues and lots with medical issues as well. So they have extreme needs when they're coming into our program that require some services, you know, and very complex needs. The other thing, the piece that was not actually brought up throughout the seminar was that a lot of these individuals also have trauma in their histories, and that's really complicated their recoveries, which is why the mental illness is so prominent, which is why the substance abuse issues are so prominent. And so being able to collaborate with the partners that are on this seminar today, between the mental health public defender's offices, the district attorney's office, the probationers at Texana, we are able to collaborate and offer these types of services. So when they come to R&R, we actually help with more of the therapeutic side. We are able to offer them specialized counseling programs that cater directly to their needs and hopefully help them to remain stable, to help promote their recovery and their resiliency in the community, get them connected to other providers that, you know, if we can't offer it, who else can we possibly send them to? So it's also nice because we're able to offer, in a sense, one-stop shopping. Instead of sending them out to a dozen different people to meet criteria for their probation conditions that they might have in order to get their cases dismissed, we're able to actually offer them things like the individualized counseling and an actual catered one that the court can approve. We can offer a substance abuse evaluation if we think that there's an issue and offer recommendations for that. They might be able to stay within services with me in order to be able to maintain, or I can make recommendations for other types of programs. We really pay attention to their social determinants of health. That would be the things like their housing. Where are they right now when they're coming out of jail? Do they have a place they can live? Is it a safe place they can live? Do they have food? Do they have clothes? Do they have a means to get around? How are they going to support themselves? As Julie had mentioned, many of these individuals that are leaving the jail have nothing but the clothes on their back. And so it's kind of hard to keep somebody stable if they're not actually, having those things. They need to have a place to sleep at night. They need to have food in their belly in order for us to be able to actually help them. So those are things that we really pay attention to. So when they get connected to recovery and reintegration, we do a holistic and very well-rounded evaluation to really determine what are their needs so we can best service them so they stay out of jail and they can hopefully stay out of the hospitals as well. So can they see it? Oh. Okay, and so here's more about the types of services that we offer. Sorry, because I couldn't see what you guys are seeing. We offer the trauma-focused informed counseling, and we also do domestic violence counseling in lieu of BIP classes. That's the batterers intervention classes, but they have to be approved by the judge for me to be able to offer that to our clients because many of them don't have the money to be able to attend those. BIP classes are usually 18 weeks long, and if you miss even one, you have to start completely over. They're done in a group type setting, and our individuals aren't necessarily able to manage that kind of thing. So it's really, and it's trauma focused. So we're really able to get in there and try to, help them so that we don't have repeat offenses for assaults. Court-ordered anger management courses and counseling, anti-theft, parenting classes. So all types of other, services to really help that individual. Relapse prevention counseling, unless they need a higher level of care, which would be more like the intensive outpatient or an inpatient program, and some case management. So we're building our resources here in Fort Bend County. So it's helpful to be able to offer that. So. And then there's at the very bottom there, the referral process is pretty easy. We're really simple. R&R is basically adults 18 and over or an emancipated juvenile. I have not had any of those referred to me. I have had a couple of juveniles who were sent to me because they were in the adult mental health court program and they needed an evaluation or some kind of a service because they're still a juvenile, but they're in the mental health court for us. And they have to have a severe persistent mental illness with a complex co-occurring issue. And they're a Fort Bend County resident. And so there's pretty much, the issues that'll get you into a referral for recovery and reintegration, and how to refer is down there at the bottom. I also do have a referral form that's pretty easy to use. You just fill it out and you can send it to the fax that's listed down there, the referral email. And so any other questions you might have, let me know and we'll see what we can do for the individual.
Thank you, Susan. You covered a lot in like 7 minutes, so you can breathe now.
Okay, and I'll figure out how to stop sharing, so.
Yeah, I just wanted to say, and often, Susan works a lot with Texana because one of the things we don't do is psychiatric services. We do not do medication management. So those recovery and reintegration focuses on those specialized interventions, like clinical interventions, the therapies, the intensive case management, and those wraparound supports. So, you can kind of tell how that fills, a needed gap. Also, we have a lot of flexibility in terms of our eligibility criteria. That's kind of like how I like to keep it, I don't know, yeah. As long as I can come up with some grants and the county funds the rest of this stuff because we demonstrate value, we're good, because our folks are mostly uninsured, medicated recipients, like 90%. So it's that high risk population that doesn't have benefits. Again, we try to connect them with Texana. Texana works very diligently to get those people on benefits so that they can have that long-term care. But, a lot of our folks, no benefits, like 99%. And we also don't charge for services. Sometimes we get calls about people that have private insurance and actually want to pay us, but we're not set up to bill. It's really to fill in those gaps. So It is 12:28. Again, next time, connection with services is going to go first, because I think that's important. And by the end of the 4.5 hours, which it's amazing that we still have 120 participants. Even if you're not paying attention, you stayed on, so I appreciate that. I think everybody has the contact information about, who you need to send your bar number to. Next time, we'll try to get CEUs if we can. It's a little bit more complicated these days. Send us, you should have everybody's contact information. We will send out the materials. I know it might be a little overwhelming. Everybody did a great job. I learned a lot. I was like, oh, I wish we tried to record it, but we couldn't record it for more than 20 minutes. But, I was thinking how this would be so useful for anybody entering into our system to just learn about the different partners and how we really all are part of the system and how we collaborate and interdependent on each other. So, again, thank you all. And I hope you have a great weekend. And it's just a pleasure and an honor to work with you all. Thank you. I'm logging off.